Everybody.
Sure.
Welcome to the Crime Commission meeting. I just want to say welcome. And
He started a rumor. He texted me the other day. So
sorry, thank you so much. Before we get started, they keep muting me. Okay. All right, so before we get started, the tech staff needs to verify people who are as unknown. The public has joined us, so we just need to verify everybody and then we'll get started. Thank you. Crime Commission meeting, we will be discussing the two studies, earned sentence credit as well as expungement. I think that this is an exciting opportunity we have to give people a second chance when they pay their debt to society. We want to reduce inequities that we see in our in our judicial system and give people a clean slate and a second chance. More importantly, we start to address with these two studies, the systematic problems we see in our criminal justice system. I want to commend our staff and the executive committee for the months of work that we put in. We had a lot of meetings and a lot of decisions to make, and I think that what has resulted is a good product. But I asked members if there are things that you think could be added or improved, or constructive criticism is certainly welcome, and comments are welcome. How we're going to proceed is that we will first have the automatic expungement study, and for the public to know that this is only phase one of the full expungement study. And so after the presentation, we will have a public comment and then a decision by the Crime Commission members on the proposed legislation. And then we will move into earned sentence credits. Looking at the agenda, I do notice that, and I'm thankful that the public, there was over 50 people who signed up. We had initially decided 2 minutes for everybody to speak, but that would require me to then decide who gets to speak and knock some people out. So instead of doing that, I would like to amend our agenda to at least allow 1 minute per speaker.
Madam Clerk, Madam Leader, I would so move at this time.
I can't hear you, Delegate Lindsay.
Madam Majority Leader, Madam Chairman, I would so move at this time.
Yeah, Madam Chair,
Yes.
I will second the motion.
All right, thank you. It's been moved and seconded that we amend the agenda to allow 1 minute per speaker. All in favor?
Aye.
Aye.
Opposed?
Aye.
All right.
Aye.
Next on the agenda is approval of the July 1, 2020 meeting minutes. And hoping that members had a chance to review them.
Madam Chair,
Yes,
I move that we approve the minutes.
thank you so much. There's been a motion and second to approve the minutes. All in favor?
Aye.
Aye.
Any opposed? All right, the minutes have been approved. I will now turn it over to Colin to present the automatic expungement study. Colin.
Thank you, Madam Chair. Madam Chair, is the PowerPoint visible on your screen?
Yes.
Thank you, Madam Chair. Good morning, Madam Chair and members of the Crime Commission. Colin Draper, Deputy Director for Crime Commission staff. Today, I will be providing the staff presentation on automatic expungement. Today's presentation will be a high-level overview of the impacts of a criminal record, expungement in Virginia, and expungement and automatic expungement in other states. The purpose of the presentation is to help inform policy decisions related to the draft legislation prepared for today's meeting. So to begin, why are we talking about automatic expungement today? Because a criminal charge or conviction can have a lifelong impact on an individual. Some of the most commonly observed impacts are on the slide before you. In addition, it is important to note that because minority populations are disproportionately represented in the criminal justice systems, these populations are also disproportionately impacted by the consequences of a criminal charge or conviction. The current expungement process in Virginia is petition-based and does not apply to convictions or deferred dismissals. The process can be challenging. A person needs to file a petition, be fingerprinted, pay a filing fee, and possibly attend a court hearing in order to have the expungement granted. There have been approximately 4,000 expungement orders issued per year over the last 3 years in Virginia. Staff wanted to see how Virginia expungement laws compared to the laws of other states. 45 states, including Virginia, allow for expungement of non-convictions, meaning cases that did not result in a conviction or deferred dismissal. However, as you can see from this map, Virginia is one of only 9 states that does not allow for the expungement of any misdemeanor convictions. Similarly, looking at this map, you can see that 36 states, not including Virginia, allow for expungement of at least some felony convictions. After determining which states allow for the expungement of convictions, staff then examine what conditions are imposed on those expungements. The items listed on the slide are common criteria for expungement that staff observed in other states. First of all, in looking at what types of offenses are eligible for expungement, staff noted that 3/4 of the states that allow for the expungement of misdemeanors exclude some misdemeanor convictions. Similarly, over half of the felony states exclude violent felonies, which staff defined as some type of physical harm against another individual. When looking at specific offenses, some common exclusions that staff noted were sex offenses, domestic battery, and DUI. Interestingly, 41 states allow for the expungement of at least some type of larceny offense. Second, staff looked at the time frame between the conviction and the expungement. The most common time frame for misdemeanor expungements in other states was 3 to 5 years. The most common time frame for felony convictions to be expunged in other states was 5 to 10 years. Now, sometimes this time period ran from the date of conviction, sometimes from the date of custody, or sometimes from the completion of the terms of an individual's sentence. A third area that staff noted was that states can vary greatly in terms of how many convictions can be expunged. 10 of the 36 felony states and 16 of the 41 misdemeanor states do not set any limits on the number of charges that can be, convictions that can be expunged. However, other states do set such limits on convictions. For example, Colorado allows 1 felony expungement every 12 months, Louisiana, 1 felony every 15 years, and 3 states, 1 felony in your lifetime. And fourth, staff looked at whether restitution had to be paid in order for a conviction to be expunged. 17 states required that restitution be paid. 4 states did not require that restitution be paid. 1 state required that restitution be noted, and 19 states did not specifically reference restitution. In regard to the 19 states that did not specifically reference restitution, some of those states required individuals to complete the term of their sentence prior to the expungement being granted, and payment of restitution may have been a portion of the terms of that sentence. Moving beyond expungement and looking at automatic expungement in other states, staff identified 4 states that have enacted automatic expungement on a large scale. All of these measures have been enacted within the past 2 years, and Pennsylvania is currently the only state that is allowing or conducting expungements in an automated fashion. It's important to note the benefits of automatic expungement, because automatic expungement can be particularly beneficial as it allows for easy access to the expungement process. Automatic expungement is initiated by the state instead of the individual, and therefore the individual does not first have to determine whether they qualify for expungement and then work through a petition-based process that can involve paying filing fees and hiring an attorney. Of the states that have implemented automated expungement for a large number of offenses, Pennsylvania is the state that stands out because, as noted, Pennsylvania is the only state that currently automates the system. Members were provided an informational brochure on Pennsylvania in terms of the flow chart and a description, which details Pennsylvania further. But a brief overview of Pennsylvania is that non-convictions are automatically expunged. Those are matters that do not result in a conviction. Then in regard to convictions, certain convictions, misdemeanors, are expunged after 10 years if the individual did not have a misdemeanor or felony conviction during that 10-year time period. Now, there are certain convictions that will disqualify a person from automatic expungement if they have those convictions on their criminal record. such as a felony, 4 misdemeanors, indecent exposure, and various other offenses that are contained on the sheet that was provided to members. California's automatic expungement process is set to commence on July 1st of 2022. The timeframes for automatic expungement of non-convictions vary in California based upon whether the individual was arrested or criminal proceedings were initiated, because not all arrests in California actually initiate criminal proceedings. In California, misdemeanors and infractions are automatically expunged after 1 year if the individual is not sentenced to probation. California also automatically expunges offenses where an individual is sentenced only to probation if the person completes that probation term without incarceration. Like Pennsylvania, there are certain offenses and criteria that will disqualify somebody from obtaining an automatic expungement in California, such as if they are a registered sex offender, they're on active probation, serving a sentence for another offense, or have pending criminal charges. Utah's automatic expungement law became effective May 1st of 2020. However, Utah is still in the process of implementing a system to actually automate the expungements in that state. Non-convictions in Utah are automatically expunged, and dismissals without prejudice are automatically expunged after 180 days. I would equate the dismissals without prejudice to be similar to a null prosequi in Virginia, where the charge could ultimately be refiled. Utah sets various standards for misdemeanor convictions from 5 to 6 years, depending on the penalty level of the misdemeanor. And Utah, like Pennsylvania and California, has certain disqualifiers that will prohibit a person from obtaining an automatic expungement, such as if they have unpaid fines, fees, or restitution, pending criminal charges, or certain convictions or combinations of convictions on their criminal history record. Additionally, in addition to Utah, New Jersey enacted legislation in 2019 to implement an automated expungement system. New Jersey has created a task force to examine the technological, fiscal, and practical issues of developing such a system. In addition to those 4 states, there are various other states that are in the process of considering such an automated expungement legislation, such as Connecticut, Louisiana, Michigan, North Carolina, and Washington. Madam Chair, in summary, automatic expungement is possible in Virginia if that is the will of the Crime Commission and the General Assembly. The draft legislation today includes many important components, such as the automatic expungement of non-convictions immediately, the automatic expungement of convictions for certain felonies and misdemeanors after 8 years without a subsequent out-of-state conviction or a CCRE reportable Virginia conviction. The legislation also limits access and dissemination to the automatically expunged records and includes protection for individuals in regard to employment, education, and housing applications. Madam Chair, this concludes the staff presentation on automatic expungement. I'm happy to answer any questions Crime Commission members may have before we proceed to the public comment phase. Thank you, Madam Chair.
Thank you. So far, is there any question from any member? And actually, since we're a small group, you could just speak up.
Madam Chairman, this is Serville. I have a series of questions.
Oh, yes. Delegate Serville, please proceed.
And Madam Chair, I have a series of questions. Should I ask you for permission on each one, or should I just keep going?
Yes, just please proceed. You can go ahead and ask and have a conversation.
Okay. Colin, first of all, I want to just get some clarity on the presentation you just gave, because I haven't really been able to participate in this discussion until now. So, first of all, you used the word expungement throughout your entire presentation. In the other states outside of Virginia where I've litigated this issue, many states differentiate between expunging and sealing and actually use different concepts and different procedures depending on the nature of the charge. When you use the word expungement in your presentation, were you sort of also encompassing states that differentiate between expunging and sealing and referring to sealing as expungement?
Madam Senator Serval, yes, in terms of the expungement use in the presentation, it could be expungement, it could be sealing, it could be a mix of both. Generally speaking, the terms tended to be interchangeable among states, but it is fair to say there's different terminology in the field.
Okay, and would you agree that, for example, the state of Ohio, expunging and sealing have very different meanings, and that, for example, in Ohio, they allow expungement of dismissals, but convictions are actually sealed and maintained to be available for periods of time to different parties and persons for different reasons. Is that fair? Are you familiar with Ohio?
Madam Chair, Senator Searle, I would have to look back to Ohio, but generally that would be my understanding is as well in terms of a differentiation between an expungement and a sealing.
Okay. And on the first part of your presentation, you went through and talked about states that allow expungements of felony convictions and misdemeanor convictions. Can I assume that in the states that you did not mention that were not automatic, in those states, the expungement of convictions is something that's in the discretion of a court after somebody has proven to a judge and a prosecutor that they have met certain terms and conditions on a case-by-case basis?
Madam Chair, Senator Serval, that is generally what we had seen in other states. An individual would have to file a petition and go before the court for a decision.
Right. So is it also fair to say from your presentation that there's no state in the country that allows or is it no state or only one state that allows expungement of felonies?
Madam Chair.
I'm sorry, automatic expungement of felonies.
Madam Chair, Senator Serval, I believe there's no other state that currently allows for expungement. However, California did just change its law on August 6th, so it's a little unclear as to whether that term of probation only that can be expunged qualifies for either a misdemeanor or a felony.
Okay. I saw it in your presentation, Colin, Utah, and I believe you said in Utah they have some kind of automatic expungement for dismissals. Does that include felony dismissals or just misdemeanors?
Madam Chair, I would have to review Utah momentarily.
Okay, Colin, is it also, while you're looking at that, with regard to the legislation that's been proposed, I did not see in here that it allows for automatic or provides for automatic expungement of all dismissals of any kind of any case. Is that in the proposed Virginia legislation somewhere?
Madam Chair, Senator Serval, yes, there is a component that would allow for the expungement of non-convictions, dismissals going forward in time.
Where in the legislation is that?
Madam Chair, Senator Serval, that would be on page 20 of the legislation, the new section 19.392.8. That is for the automatic expungement of offenses not resulting in a conviction going forward. There are certain conditions set in terms of dismissals or null prosecuted offenses that relate to charges that result in a conviction.
Okay, so just so I'm clear then, under this legislation that's proposed, say, for example, there was somebody charged with murder, say gang-related murder, and say that the victim or the lead witness was murdered the day before trial and a charge got dismissed because the victim wasn't available. This would provide that would be automatically expunged?
Madam Chair, Senator Serval, would be dependent upon the circumstances of the case. There is a provision that would allow the Commonwealth to notify the court that it intends to reinstitute the charge, and therefore the charge could not be automatically expunged at that point. But it would be dependent upon the facts and circumstances if the Commonwealth would proceed without that witness.
Okay, I'll go back and look at that page statute more carefully because I didn't really look at that carefully before today. Did you all do a survey of prior Virginia proposals that other legislators have made before you came up with this proposal?
Madam Chair, Senator Survell, we did look at other legislation that had been proposed in regard to the expungement of various offenses in Virginia, but did not do a deep dive into all of those different proposals.
Okay. In 2010, I introduced legislation that would have allowed for an expungement motion to be made at the moment of dismissal so that it could be done right there with the prosecutor, the judge, the defendant, their lawyer they've already paid money for, right there in the room. Did you look to see whether any other states have used that method to eliminate the access problem you talked about where you have to pay for another lawyer to come in and deal with the situation?
Madam Chair, Senator Survell, we did look at that issue. I don't believe we have a specific count, but I do recall that coming up in other states, and that is how we attempted to craft this legislation, the 192392.8 that I referred to, where the dismissal would occur be entered by the court at the time of, the expungement would be entered by the court at the time of dismissal or null prosequi.
So you tell me there's other states that allow you to make a motion at the moment of dismissal for expungement, and then the court, as a matter of discretion, can do it at that time?
Madam Chair, Senator Survell, there are other states that we did come across. I don't have a specific count, but I recall the statutes that those do exist.
All right. And are there any states that provide for court-appointed counsel to represent people in expungement proceedings if they're unable to afford an attorney themselves?
Madam Chair, Senator Survell, we did not examine that issue, so we would have to look into that further and get back to you on that.
Okay. So on the specific legislation that you all proposed, I looked at it myself a little bit. So the list you all have has a series of offenses, including class 4, 5, and 6 felonies. Is it fair to say that under the legislation that's been proposed, it would be possible for somebody to still be in prison, say, for example, for involuntary manslaughter on a 10-year sentence, and they get an automatic expungement under the way this is drafted?
Madam Chair, Senator Survell, that would not be possible for felony offenses. We ran the 8 years from the date of conviction or release from custody, whichever occurred later.
Okay.
Somebody incarcerated would not be able to get an expungement.
And why was the policy decision made not to run it from the end of probation?
Madam Chair, Senator Survell, the policy decisions are a matter of preference by the executive committee.
And, and I will take my opportunity to speak right now about that. It was decided that this is to be an opportunity for people after they paid their debt to society to have a clean slate. And I'll remind the senator if there are any suggested changes he would like to see to the proposed legislation, he can submit them. And on a theme that I hear recurring is I heard questions about court-appointed counsel. If the senator would if you can call and go back to that first slide. When someone has paid their debt to society and has started a new life and tried to become clean, I think for us as attorneys, going through the court process is a no-brainer. It's easy because we are used to that. But when someone is trying to live outside the judicial system, I think that we as a society have a moral duty to make sure that we have use every tool that we can to assist that person so they do not have to go back through the judicial system. It is a daunting process to go and try to go in front of a judge after you've tried to live clean and not have any convictions.
Okay. Thank you, Madam Chair. Could I ask a few more questions?
Do you have another question, Senator?
Yeah, I have a couple more.
Yeah.
Okay. So, Colin, in my experience, the issues that arise because of somebody's continuing criminal history typically exist because private background check companies basically take all the data that's out there and they aggregate it. There's certain data brokers that take it and sell it and move it around. There's probably hundreds, if not thousands of companies at this point that move this data around and sell it. I don't see anything in this legislation regarding the liability for those companies or anything that requires them to scrub their records or creates any consequences for them continuing to publish information like this. And of course, part of that is governed by the Fair Credit Reporting Act, which would preempt some things we'd like to do, but not others. Can you describe for me what the executive committee's thinking was in not dealing with that aspect of the problem, if the point is to try to address how this actually affects people when they apply for a job or insurance or housing?
Madam Chair, Senator Serval, that is an issue that we looked at in regard to these private background companies. We know there's a lot of background check companies scraping the court site, getting that information. And it was something that we looked at in other states. There are several states that had legislation to address that, such as, I believe, Minnesota, Louisiana, North Carolina. And we are continuing to work on that with the hope of including that in legislation as we look at more of the petition-based expungement for the regular session in 2021.
Okay. Did you all look at the bill that I introduced with Delegate Lupasi 4 years ago?
Madam Chair, Senator Serval, I do not believe we saw that bill. We were looking at the other states' laws and did not do a survey of Virginia proposed legislation on that topic.
And I'll remind the members that that bill was 4 years ago. What the Crime Commission's staff had in their hands were bills that I referred to the Crime Commission.
Okay. Colin, also, there's an ongoing, as you know, the House and Senate passed legislation last year jointly by agreement to study barrier crimes. And we also had a separate bill that came through the Senate to look at data broker liability. There's a current work group meeting on that. How did you all figure that this process would square with that joint study we still have to do and with the data broker work group that's to proceed over the next 4 months?
Madam Chair, Senator Serval, we're aware of some of the work going on this topic. And in regard to this legislation, there is a delayed enactment clause till, I believe, approximately July of 2024 in order to get all these systems automated in place. So the thinking from staff and from the executive committee is that modifications could be made to this legislation depending on the outcome of current work that may impact the automatic expungement process, or the petition-based, for that matter, as we look toward January.
Okay. Madam Chair, I have one last question. With regard to this list that I have in front of me of I guess it's about 20 felonies, and I can't count how many misdemeanors that are supposed to be subject to automatic expungement. Can you describe for me sort of how that list was generated? Because I don't understand whether it was evidence-based or whether it was just policy decisions or what, because it would seem to me that if we're going to start with expunging automatically low-risk things, we'd say start with traffic offenses, things like reckless driving or speeding tickets, as opposed to, felonies. So can you describe for us how this list was arrived at?
Madam Chair, Senator Serval, the list initially came from criteria set forth by the executive committee to remove compounding or stacking offenses, DUI offenses, certain violent offenses, and then it was narrowed down further. Staff reviewed the entire Title 18.2 for all the offenses in the code, presented those, screened those out as requested by the executive committee, presented other members or other offenses to the executive committee for discussion, and some of the those choices by the executive committee were included in today's legislation for a discussion to be had amongst the full Crime Commission on what is included and excluded from the legislation.
Okay, I don't have any other questions right now, Madam Chair.
Thank you, Senator. Anyone with a question or comment before we go to public testimony?
Madam Chair, I have a question.
Yes, Delegate Adams.
Thank you, Madam Chair, and thank you, Colin, for your work in this case. I have a couple of follow-up questions that relate to what the Senator was asking you about, and one has to do with bills that were referred. from some previous information that I saw, I think there were 27 bills referred relating to expungement. Did you actually consider those bills in the course of your work and the drafting of the legislation?
Madam Chair, Delegate Adams, we reviewed the bills. However, I believe there was only one of the bills that dealt with a automatic expungement concepts, and I believe it might have been from Senator Saslaw that I recall seeing. We had to look at two other states, such as Pennsylvania primarily, and others that had drafted legislation to do this automated-based expungement, which is different than the petition-based expungement that has been proposed in the bills.
And if I could ask you about when you looked at other states, and you've got a lot of data compiled in terms of what other states do, did you also, and it doesn't, because I don't see it in the presentation, but was there any sort of analysis to show correlations between states in terms of categories for which states have a more liberal expungement process than others? For instance, how it might connect to that state's ranking recidivism, or in terms of, say, restitution completion, restitution payments?
Madam Chair, Delegate Adams, we did look to attempt to determine how many expungements are granted in other states. However, what we found is that that number was very difficult to find in any public available fashion. Some states do make that public, but many states we just could not find anything on. And then in regard to the analysis for purposes of what is being proposed in this legislation, because it's so new, we could not conduct such an analysis because Pennsylvania has only been doing that for 1 year. One other hurdle to such an analysis was noted early in the presentation, that because these petition-based systems can be more cumbersome for defendants, it's hard to compare that type of system to an automated expungement system where you can expunge larger levels of convictions and non-convictions than a traditional expungement-based system.
But in terms of any sort of analysis that shows, data points or correlations with certain criminology data points like recidivism or restitution, we just don't have that. That's what you're saying.
Madam Chair, Delegate Adams, that's correct. We don't have that data point correlation.
And am I understanding you correctly then to say that Pennsylvania is the only state that has an acting automatic expungement process?
Madam Chair, Delegate Adams, it's the only state that has a large scale. I believe Illinois has implemented an automatic expungement for marijuana after they decriminalized marijuana. I believe North Carolina has a small scale system for individuals 16 to 18 years old convicted of a first offense. I believe there are some other states out there that have very narrow type expungement systems. But in terms of the states we looked at, they were looking at a broad class of offenses that were going to be eligible for automatic expungement.
All right, and lastly, if I could just ask you,
Yes.
is it fair then to say that the draft legislation that we've been sent this morning, that most closely resembles the Pennsylvania model?
Madam Chair, Delegate Adams, yes, it most closely represents what is done in Pennsylvania, with the caveat of what our OES court systems and state police systems will be able to do in order to put such a process in place.
Thank you, Madam Chair.
Thank you, Delegate.
Madam Chair, John Edwards here. I have a question.
Yes, Senator Edwards.
As I recall, last time we were talking about the word sealing. That is, sealing the records means that the public does not have access, but that the information can be obtained by the FBI and certain for certain intelligence reasons and for people who would have reason to find out, even though the public would not have it. Am I correct that I've noticed that we did not use the word seal in this this document here, but maybe it's implied in the concept of definition of automatic expungement. Could somebody explain that to me? That because I remember we did talk about the term seal. That's really what we meant. Expungement, in the sense of tearing it up and not ever existing anymore. We were not going there, but rather we're going to, because there are a lot of like the FBI and other agencies and for example, banks, financial services agencies, they need to know this information. Can somebody explain, is that implied in the term automatic expungement, that we're really talking about sealing? Is that correct?
Madam Chair,
Yes.
Senator Edwards, what you're talking about is the way we define automatic expungement. And with automatic expungement, it would be like sealing in other states where the record is still available. So with the automatic expungement, that record would still be available in the criminal history record system as well in the court system. Access would be limited in the court system as well as the criminal history system to purposes determined by the General Assembly. So essentially the automatic expungement is granted, the records are maintained, but not accessible except for the reasons determined by the Crime Commission and the General Assembly in the final legislation. So the records do not completely go away, they are still using it.
I think,
Another question, one more
Senator?
question. We were talking about like reckless driving, that type of thing. DMV keeps these records for purposes of points. And I guess insurance companies are interested too. Courts are interested when it comes to somebody's been charged with a driving offense, whether it's a misdemeanor like reckless driving or just speeding. I assume those records would still be maintained by DMV and available for the prosecutor and defense attorney and to the citizen as well. Is that correct?
Madam Chair,
Yeah.
Senator Edwards, yes, that is correct. This legislation before the Crime Commission does not deal with any offenses outside of Title 18.2, except for, I believe, underage possession of alcohol and I can't recall off the top of my head, but maybe some of the few misdemeanors that are required to be reported to the CCRA. So any traffic offenses under 46.2 right now would not fall under this automatic expungement legislation.
Thank you.
Thank you, Senator. I think Deputy Attorney General Pearson.
Good morning. Apologies, my camera's not operable and my computer's in the docking station. Wanted to comment on a few things. One thing is having sat on some earlier expungement committees, particularly with the Virginia Criminal Justice Conference, I've seen very thorough, I'll say, looks into this issue, and what was put together by the Crime Commission is quite comprehensive and very well done globally. One of the things that stood out as a potential concern to me pertains to the automatic expungement that's available if a conviction is not acquired, particularly for crimes such as sex crimes, where those cases can be very difficult to prosecute, and the Commonwealth may not be able to bring the case back in 3 months. It may be that it is an underage victim, that the trauma of putting them on the stand and testifying in a public environment may do even greater damage to that individual, such that the prosecution has had to make a very difficult decision, but perhaps it is not something that should qualify for automatic expungement, but that is not one of the options that appears to be available to the Commonwealth and objecting to it. And I think the point that Senator Serwell brought up regarding if you've lost your witness for a homicide, I've had cooperating witnesses who have been shot and killed, again, the automatic expungement. And so one of the things that I thought about was whether or not for offenses that do not qualify for the automatic expungement where there is a conviction, anything that's not on that list should still perhaps require a petition. because obviously we've identified a class of crimes that we think should qualify for automatic expungement, and to be consistent with that list. Perhaps if it is a criminal offense that isn't on that list, then individuals, they still have the option for the expungement, but perhaps they would need to petition. Or there's a catch-all option that is added in the alternative on page 20, where the Commonwealth has certain options to object. At the moment, they are not able to acquire the conviction to proceed with other other reasons that may be compelling to the court. And so that was my thought on that particular issue. And then the other thing that came to mind along the same lines of particularly sex crimes and certain crimes, I note that law enforcement has a duty, or individuals applying for employment with law enforcement will have a duty to still list relevant crimes. And we don't mention schools, and we don't mention individuals who will have care and control of children. Now, I do think that is captured where it says where the federal law would require certain disclosure, but it may be helpful in the category where we say those applying for law enforcement have to list certain crimes, that we also say those who are applying for positions with schools, institutions, or who will have care and control over minors. But again, it is perhaps, I believe, captured maybe with the federal background, but I'm not certain that it's absolutely clear. And I know when the other language was put in place that pertained to law enforcement, at that time, we were looking at earlier legislation, we were looking at marijuana and underage drinking. And since we've expanded the list, it may be, if we're going to do automatic expungement if the conviction isn't garnered, we may want to include the capacity of where individuals will have care and custody over minors in teaching settings. Those are my comments. Thank you, Madam Chair.
Thank you so much. Colin, given the Deputy Secretary's comments, and of course I'd like to hear from members regarding children and schools, sort of those crimes. Could that bill be amended? I just want to also get a feel from the committee how they feel about that.
Madam Chair, in regard to the two comments, the first comment in regard to page 20 to 21, the various exclusions from charges being, or pardon me, non-convictions being automatically expunged, we could certainly put limitations in that portion of the bill, either as Deputy Attorney General Pearson stated, that the Commonwealth could list other compelling reasons, or the Commission could include certain specific offenses, such as sex crimes that are not eligible for automatic expungement. We certainly have a lot of flexibility. Just as we define which crimes are eligible for automatic expungement, we can identify certain crimes that are not eligible, depending on how the Commission wants to go in that regard. And then in regard, Madam Chair, to the comments on page 25 about schools, institutions having access or being made aware of the records, we could certainly add that provision in there as well, that specify that schools and other institutions where you're applying for employment have contact with those individuals could be have access. In addition, what we could do, Madam Chair, because it's been pointed out to Commission staff, there's a number of instances under the code where a person does not isn't eligible for certain employment, or if they have a record such as a magistrate not having prior felony conviction, a bail bond, not have a certain felony conviction. So what we could add in there was something that what federal law, the Clause 2 on 1013 talks about. We could have a similar clause where Virginia law requires the employer to make such an inquiry. That information will also be disclosed. That was a suggestion we had received from some of the feedback we got on the bill.
Okay.
So both of those are fixable in that fashion.
I don't know what the will of the committee is. I would like those changes, but
Madam Chair,
yes.
Delegate Kruzak, I would certainly entertain it. I mean, I would be supportive of a motion to that nature if the Deputy Attorney General wants to make that.
Right. And I apologize, I couldn't hear you. Everything was missing for those amendments. I didn't, Paul?
I'm sorry. Yeah, Madam Chair, I certainly would be supportive of a motion to amend the bill by the Deputy Attorney General to her points. I think those were all
Right.
important. Yeah.
Is there a second on that motion?
Well, I hadn't made a motion. I was Madam Chair, but
All right, so
the gentleman may want to.
well, I guess, and Kristen will tell me if I'm wrong, I can make the motion to amend those, make those amendments regarding the sex crimes.
If you'd like, I'll make that motion
Yes,
for what Colin was detailing.
right. And I second it. We are voting, so all in favor? Aye.
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 Anyone opposed? All right, those amendments are made. Sarah Lucas. Okay. Senator Serville, you had a concern about third-party access. Is there an amendment you would like to see on the bill?
Madam Chairman, my concerns are so numerous, I don't think we're capable of resolving them within a couple hours of this hearing. So I'm not going to make any motions to amend. If this comes out of the commission or makes it to the Senate, I'll deal with it at that time.
All right, thank you, Senator. All right, I think we're now at time for public comment.
Madam Chair,
Yes, Lori.
this is Lori Haas. I just had a question for staff, and perhaps it can be answered at another time or via correspondence, but can you make more clear what interactions, if any, with the judicial system during that 8-year period would put a hurdle up to an automatic expungement or preclude it? Are there any types of infractions or behaviors or, again, interactions with the judicial system that would interrupt or push back that 8-year time frame or make it unavailable, make the automatic unavailable? Am I making my
Chair.
clear? You know, if
Yeah,
you know,
yeah,
is
I can answer that question.
protect.
Yes, during that 8-year time period, the individual would have to be conviction free, meaning they could not be convicted of another offense. Therefore, an arrest not resulting in a conviction would not disqualify that person from automatic expungement. The legislation is drafted to capture convictions from out of state as well as in-state convictions that are reportable to the Central Criminal Records Exchange. So anything in Virginia that a person has to be fingerprinted for and a report sent to the state police for inclusion on the criminal history would disqualify them from automatic expungement, but an arrest would not.
Thank you. But domestic violence protective orders would not interrupt.
No, that would not. Just the protective order alone would not if there was no conviction.
Thank you.
All right, we'll start with public testimony now. And I remind public to accommodate everyone, so everyone has the opportunity to speak. It's 1 minute first. On automatic expungement is Patrick McKenna.
Thank you, Madam Chair, members of the commission. Can you hear me okay?
Yes.
Thank you. I appreciate the opportunity to speak on behalf of the Virginia Coalition Against Human Trafficking, which is an alliance of service providers, attorneys, survivor advocates, and community members working to remove such barriers as the commission is studying and speaking about today. My history is as a 30-year practicing attorney. 6.5 years of that time was spent in the Virginia Beach Public Defender's Office, where I represented numerous individuals who are convicted of various crimes. They often use a colloquial expression, look, I did the crime, I got to pay the time. But unfortunately, the time never really seemed to end because the convictions to which they paid their time, whether by incarceration through probation, never ended. That record followed them everywhere. From a human trafficking survivor's perspective, of course, we were hoping actually to have at least 2 survivors speak today, but the process of even coming before the commission proved to be a bit daunting from them, and they asked to be excused from being able to do that. So from our perspective, the more charges, convictions that can be included under this consideration of automatic expungement or sealing would be greatly appreciated by the many survivors that the coalition represents. So I really would.
Your time's up. I'm sorry.
Thank you.
You can wrap up. Oh. Next, I have Rob Pogenglass, and I apologize if I mispronounced your name.
You got it. Thank you.
Thanks, and I will give you a 10-second warning. You have a minute.
Okay. Thank you, Madam Chair. My name is Rob Pogenglass. I work for Legal Aid Justice Center. This expungement effort is so important. We're thrilled that the Commission is being so ambitious. We wholeheartedly support the expansion of expungement to include offenses that disproportionately affect Black Virginians and other people of color. We support the provision that allows expungement of records without prepayment of fines and costs, which will make this law accessible to those who need it most. And we also support the creation of an automated process, which, because the current petition process creates numerous barriers that discourage expungement. Currently, however, the bill lacks strong protections to hold the background check industry accountable for ensuring that the information it sells is accurate. And without those protections, the bill will not accomplish its intended purpose and could lead to increasing reliance by employers and landlords on private databases that contain expunged information. We believe this is such an important piece of legislation. It deserves the time and attention of more stakeholders, particularly those in the community who are most likely to be affected by it. Attorneys who directly represent people petitioning for expungement and consumer advocates who are experts in the background check industry can also offer invaluable technical expertise. We hope that you will take up this legislation in 2021 to allow adequate time for the public to weigh in. Thank you very much.
So, I do have a question for you. There is a delayed enactment on this. So is it still your position that with the delayed enactment and that you would like for us to wait? Because there's a delayed enactment in the bill, which will allow us time to work with third-party vendors and iron out that issue.
If there is adequate time for public comment and other stakeholders, members of the community to weigh in, the delayed enactment is fine. Thank you.
Thank you so much. I appreciate it. And Mark Bernard from the Supreme Court.
Thank you, Madam Chair. Again, my name is Mark, Office of the Executive Secretary of the Supreme Court. Thank you for your time. I actually meant to put my hand down. I didn't have any comments on this first section here. Any comments, I would defer to Ms. Christy Wright of the Office of the Executive Secretary. Thank you, Madam Chair.
Thank you. Ms. Wright. Ms. Wright, are you there? Right, I'll move on. Next is Donna Shiflett. Is Shiflett? I'll move on to Cameron Roundtree from the Virginia State Bar.
Good morning, Madam Chair. This is Cameron Roundtree. I'm the Deputy Executive Director of the Virginia State Bar. I have a very narrow request, very narrow ask, and that would be that the State Bar be included in the list of entities that are permitted to have this information disclosed or disseminated under 19.2-392.12C. And that's for a couple of reasons. We're not so concerned about a retrospective look at someone's background or history. What we are concerned about is lawyers who may take advantage of this automatic expungement to fail to disclose information which they are obligated to disclose to the bar under the rules of professional conduct. So in particular, with regards to 8.3E, does impose a self-reporting requirement that we believe would be minimized or reduced as far as a lawyer's desire to report something if they felt like they could last the 8-year period of automatic expungement. Importantly, for the bar and the disciplinary system in general, there is no statute of limitations on misconduct. Therefore, it may incentivize some dishonest lawyers to never disclose an incident that would lead in a charge, an arrest, or a conviction. Same thing with regards to enforcing it. We need to be able to access those records so that we can enforce our disciplinary system. And then lastly, we're concerned about the impact if clerks do not report this to the bar because they feel like the conviction or arrest will be expunged automatically and they don't feel like it's worth it to share an incident of a lawyer having a misconduct. So that's all we would ask, just for a narrow exception to be included. Thank you.
Thank you so much. I'm going to go back to Chrissy Wright from the Supreme Court.
Thank you, Madam Chair. I apologize. Had muted myself still.
No worries. 1 minute. Yes.
I wanted to address two issues today. The first is immunity. The implementation of this bill places a significant reliance on programming and actions undertaken by staff in the Office of the Executive Secretary's IT department, as well as the actions of clerks, to ensure that those expunged records, which will remain on the shelves and in the case management system, are not made available. We have repeatedly emphasized that many of these clerks' offices are severely understaffed, and with the ongoing public health emergency, many courts are unable to meet current demands and will face daunting backlogs for months. Under this stress, if a clerk or IT staff person makes a mistake and as a consequence, an expunged record is made available, they should have immunity from a suit arising from their actions or omissions that are not due to gross negligence or willful misconduct. Similar language is already included for clerks and the executive secretary in the Code of Virginia, and I'm happy to supply those some language and those examples to staff. Further, the other thing I wanted to, you already touched on it, but that is having access to expunged records for hiring. Colin noted magistrates. I will also note judges and substitute judges by statute cannot have a felony conviction. I would also add that clerks are very important in hiring. We need to ensure that we can trust them. They have access to funds. They have access to personal identifying information for individuals that, if misused in ways, could negatively impact the criminal justice system as well as individual lives. And so I would urge you to allow those persons that we be able to, for hiring purposes, be able to see those expunged records, and that they should have be included just as those who are currently listed, such as even volunteers for state police, other law enforcement entities. Thank you.
Thank you so much. John Jones, Virginia Sheriff. All right. Mr. Jones, are you here? I'll come back. I'm going to move on to Judy Peterson. Ms. Peterson, I know you're here on two matters. Right now we're on automatic expungement. Right.
John Jones is ready.
Okay, John Jones is ready. Mr. Jones, welcome. You have a minute. Mr. Jones, I think your microphone may be muted. I understand you're talking, but we can't hear you. All right. So I'll ask our team to, I'm going to move on and we'll try to get Mr. Jones unmuted. Again, Judy Peterson. Ms. Peterson. All right, we're going to move on to Jeffrey Charity.
Good morning. Can everyone hear me?
Yes, right now we're talking about expungements. I know you signed up for two things, so you have a minute to talk about expungement. Welcome.
Thank you, Madam Chair. Honorable committee members, my name is Jeffrey D. Charity. I currently serve as the chairman of the Chesapeake Criminal Justice Board. I've also started a nonprofit for reentry, excuse me, which is called Strategic Advocacy Ventures and Grassroots Engagement Incorporated. The number one issue when I go to prisons like St. Bride's and Indian Creek is the number one question that I'm asked by incarcerated individuals is the possibility of an expungement mechanism that they may be able to access upon their release and successful rehabilitation. And I informed that currently that mechanism does not exist. So I want to thank this committee for taking up this very, very important issue. In 1997, I myself was convicted of a criminal offense, and I have been a convicted felon under that status since that time. I sit on boards and things myself, but it has been a substantial impediment to the ability for me to access housing, employment, numerous other things. But I would implore that this committee be able to come to a consensus and hammer out something, because I myself have submitted legislation for years and just happy to see that that something is being done to move the needle. That being said, I just accepted a position at the Norfolk Commonwealth's Attorney's Office, and I would look forward in the future of being able to contribute to anything that this committee is doing in the way of expungements or anything else. But I thank you all for your work and your service, and God bless you and stay safe. So thank you.
Thank you so much. I appreciate you. John Jones is back.
Good morning. Good morning, Madam Chairman, and thank you for taking my testimony. I apologize for the technical situation. I'm representing the Virginia Sheriff's Association, all of the sheriffs and over 8,400 deputy sheriffs, and there are two major concerns initially with what I've seen with this bill. And one is, of course, we want to know the background to the extent possible of every deputy sheriff we send on a 911 call. And I think the public has the expectation that when we send deputies out to provide the service, we want we want the best. We want to know if there's anything in their background that would define them as unfit to be a deputy sheriff. I'm not sure this bill gets there. I see language in it on page 17 that allows the person whose record is affected to not deny it if you're asked, but we want to know what those records say. The second major concern we have is the cost. We keep law enforcement records in every one of our offices, and I know the local police do. And we know that there will be a significant cost to implementing this, and I haven't heard any discussion on that. So we'll stay tuned to this issue, Madam Chairman and members of the commission. But these are at least our initial concerns, and I'm sure as we move through, you'll be hearing more from us.
Right, and Mr. Jones, you should know. Thank you so much. You should know that in the bill we do cover those who are going into law enforcement, that those records are accessible, because if there are discussions on reform, we thought that was important for public safety. And in terms of costs, I'm working with the chair of appropriations, so we want to make sure that you have the resources to do what you need. So I just wanted you to know that we are mindful of that, and that first concern is covered in the bill. Thank you. Sarah McClellan from Stafford. Yes, you can move her over. Ms. McClellan? You can unmute.
How about now?
Yes, we can hear you. You have a minute. Welcome.
Thank you. As we all know, I'm sorry, I'm going to start over. If violent perpetrators of murder and sexual crimes are included in earned sentence credits, I would respectfully submit that voting yes decidedly pits you against the very reform that you are trying to enact. Including these perpetrators is the very definition of injustice to victims, their families, individual communities, and the society as a whole. When it comes to crimes against children as well as rape and murder, justice must be on the side of the victim. If passed without the exclusion of rape and murder of all varieties, this bill will re-traumatize victims and their families. That is not justice. My sister Jeanette was murdered by a serial rapist and killer. After she was raped, she was repeatedly stabbed to death. She was his fifth victim. I wish each of you could just feel for a moment the cumulative ripple effects that loss has had on her immediate family, friends, and the community as a whole over the years. He was eligible for parole just 18 years after these heinous crimes. Just the mere suggestion that this man could be eligible for release for good behavior is re-traumatizing. Those of us still here get to live with the details of our loved ones' victimization every day for the rest of our lives. We don't get any respite from that. We get no comfort. We don't get paroled from the pain and horror that was inflicted upon the people that we love. Our pain cannot be expunged. In your efforts to right the longstanding wrongs of the criminal justice system, please vote no to earn sentence credits unless violent perpetrators of sexual crimes and murder in all forms are excluded. Voting for this bill is effectively changes your attempts at criminal justice reform into the exact opposite. No justice whatsoever. The people who need justice the most are the victims of violence and their families. We put our faith in you when we voted for you. Please do not let us down. In summary, rapists should not have automatic expungement. Child molesters should not have automatic expungement. Murderers should not have automatic expungement. School shooters should not have automatic expungement. Violent hate crime perpetrators should not have automatic expungement. And serious violent crimes perpetrated against women and children should not have automatic expungement. Please vote no. Thank you for your time.
Thank you so much for your comments. And just please know that those crimes you listed are not part of the automatic expungement proposed legislation.
Good. Thank you.
Yes, thank you. I appreciate you coming virtually. Next is Gayleen Knoyton.
Good morning, Leader Herring.
Good morning.
The Crime Commission. My name is Gayleen Knoyton. I am the Virginia State Conference NAACP Political Action Chair. We support automatic expungement. Many of our members, we have members and people in the community that are ex-offenders and being good stewards in the community and in their churches. And so therefore they should be able to have their rights automatically expunged. The last thing I want to say is that many of our Commonwealth attorneys they will do automatic expungements for free. But many people don't know that. And so therefore they pay an arm and a leg to attorneys. And therefore, you know, there's many disparities because many can't afford an attorney to have their offense expunged. If a person can get their rights restored within months to vote, then certainly after 8 years with no infringements, they should have automatic expungement. Thank you.
Thank you so much. Next, Brooke Glisson, and I apologize if I mispronounced your name.
No problem. Can you guys hear me?
Yes, welcome.
Thank you. Good morning, Madam Chair. Thank you for the opportunity to speak to the committee today and for considering this proposal. I strongly support reforming Virginia's justice system to embrace auto expungement. As someone who works with justice involved and formerly incarcerated people on a daily basis, I can tell you that auto expungement would be life-saving and life-changing for thousands of my fellow Virginians. Virginia's justice system is one of the harshest in the entire country. Frankly, it's shameful that Virginia is one of just 3 states that still permanently disenfranchise people with a felony conviction. But on voting, a permanent felony record prohibits these individuals from reclaiming their lives. It excludes them from jobs, education, safe housing, and numerous other essential elements for healthy, productive, crime-free living. To put it simply, Virginia's current justice system all but ensures these individuals will return to it in some way. Let's not act like the cost of implementing auto expungement and other measures like this will cost more than repeated incarceration, bloated community supervision caseloads, and constantly expanding police forces. Also, let's not beat around the bush. In Virginia, our justice system and its actors disproportionately surveil, stop, search, arrest, prosecute, sentence, incarcerate, and reincarcerate our Black and brown neighbors. Auto expungement would, I hope, disproportionately benefit these communities that have been decimated by permanent felony convictions with no chance for redemption except an individual exception and pardon from our governor. I really hope that we can move Virginia into the 21st century and give our citizens, like Mr. Charity, who spoke earlier, the second chance that they've clearly earned and deserve. Thank you so much for the opportunity to speak and for considering this proposal.
Thank you so much. Just want to make sure Russell McGuire.
Good morning, Madam Chairman. Are you able to hear me?
Yes, I am. Thank you.
Thank you so much. Thank you so much for giving me the opportunity to speak. A little bit about my background. I have been a career prosecutor, other than a few years I took off to actually teach law at Virginia Union University in Richmond, Virginia. And I will tell you, as a baby prosecutor, I actually set up a automatic expungement program for people that were wrongly charged. Often people will use someone else's identification and get arrested, and I did not feel it was fair they had to pay for the process. So we had a great system, and stuff like that I think is great. What concerns me about this bill is a couple things that I'm not going to go too long on it, but I'll just have them for food for thought. One, in Virginia law, if you discuss something that's been prosecuted, you can be criminally prosecuted yourself. And I worry about victims of crime talking about someone who harmed them could then be victimized by the law. Two, generally we enact laws to say this conduct should be illegal. This actual bill says illegal conduct should be legal. And it's hard for me to understand lines 674 through 683, where it says not only can you can deny this, it's not perjury if you make this statement to any local or state government, which I assume would include the courtroom. And I think that sends a very bad message. And I'd ask that the drafters to look at that issue, because that seems inconsistent with jurisprudence. And thank you so much for the opportunity to talk. Oh, one more point. I hope you all realize, and I'm sure you do, that Virginia has one of the lowest violent crime rates in the nation, something we're all very proud of. And I think we need to watch if we go too far. And I'd ask you to consider that. Thank you.
Thank you so much. I believe that's it for the public testimony on expungement. I just have a question for staff on procedure. One of the testimonies from the State Bar and the Supreme Court, it seems sort of reasonable request for access for bars, for the bar. Oh, I'm sorry, Lynn Bennett. I apologize. Lynn Bennett's still in the waiting room. I apologize. I wasn't on my written list.
Good morning.
Yes, welcome.
Thank you. So in my background, this is where I spend most of my time when I'm not fighting legislators in Richmond on predatory lending. The overwhelming majority of the background check and expungement litigation nationwide has been mine. I've been working with Sharon Dietrich of Community Legal Services for a decade plus, have litigated with her. And in fact, we were to meet regarding the next steps for Clean Slate at our conference in Tampa before COVID hit. And as background, two things. First, Madam Chair, you and the commission members are to be commended. This is a critical, necessary step. Having taken countless depositions and read millions of pages of documents, there is no research out there that is contrary to this. Maybe the hunch is wow, if people will want to commit crimes or they're going to be bad employees, there is no evidence. Walmart didn't have it. Amazon didn't have it. The background check companies don't have it. This commission's effort is critical. On the other hand, like Legal Aid Justice Center and others, we believe that the symbolic changes here will be detrimental to the very cause we have fought for, which is the failure to deal with private databases. People don't use the Virginia State Police, and they don't use contemporaneous checks of the records of the executive secretary. Instead, they web scrape or use outsource, and this is true universally, overseas work to gather on the internet the information as soon as the conviction happens. And this bill would incentivize the shift to these private historic databases even further away. It's not just a matter of it's imperfect. It would harm the very issues that you, so many others have been fighting for. You have to have automatic expungement. You cannot stop this fight. It is critical, period. But it is also critical that you add, and you cannot pass a law that creates these incentives, that you add a remedy to deal with private databases and to deal with the fact that these private databases are become obligated to go back and check before they sell a record on our Virginians, that they check what is the status of that record now in 2020, because they keep these forever and nobody buys the $20 state police, no private employers really, no major ones do. So at one hand, really you have tremendous assets in Virginia, the top 10 in screening, and with all due, with shedding false modesty, the top background check litigators and advocates here. Most of the cases in this field have been in Richmond federal court, 80+%. You need to involve those. The same folks that won the State Bar Pro Bono Award, that were on the boards of Legal Aid Justice Center, the Virginia Poverty Law Center, and numerous others. I don't want to suggest that this is a cause which you should lighten or take your foot off the gas on, but you have to do this. It's not just a matter of improving it. You've got to add something to deal with the private databases, or all of this effort to deal with expungements will actually incentivize the complete continued shift to these historic databases. And that's where the real problems occur for all the people that you and we care about.
Thank you, Mr. Bennett. If I could just use my privilege as chair, let me ask you this. Because there's a delayed enactment till 2024, can we introduce legislation in January to address that issue, that we are making sure that we're taking care of that, but there's no reason to delay this?
Well, the concern I have is that, and I hate to say publicly, because I strongly disagree with those folks that believe that automatic expungement is bad. I think it's critical. It's what we've been fighting for. The problem with the delayed enactment is that you're going to face significant efforts by the Consumer Data Industry Association if you begin to try to and I would be surprised if you can obtain the necessary efforts we've been spending. We've tried for years to cause, and without that, this bill becomes a bad bill in areas of employment and tenant screening. I would love the opportunity to talk at length, to provide details and documents and different legislative alternatives that Sharon Dietrich, Community Legal Services, and our folks have always worked on. So it's sort of in the same position that Legal Aid Justice Center speaker was in. I'm not criticizing this effort. I am saying that if you do it halfway, it's going to be much worse. And so the delayed enactment, as opposed to a reenactment clause, which we've suffered from forever in the predatory lending battle, so I hate to even suggest that. But a delayed enactment leaves the possibility that you're not going to have any solutions to deal with the critical part of this, which is how this data gets out there, how it's sold, and without some effort to at least provide those that do the web scrape of the executive secretary websites have to identify themselves and commit to do contemporaneous searches. You're better at this, obviously. I don't know. This has to get through. Automatic expungement has to happen. We are easily one of the worst in the state. I'm sick of litigating the laws of other states that protect expunged consumers and never having that option for Virginians, given that there is zero evidence out there that in any of these cases, whether it's a Title VII and employment discrimination or Fair Credit Reporting Act, zero evidence that there's a basis for this. But the problem, if you deal with this example, one of the real common issues we've seen is in one of the barrier offenses, the charge of a felony charge, overcharges made, in my opinion, overcharges of distribution. And the goal being, well, we'll get this defendant to plead down to possession. And so you have a circumstance where the web scrape has picked up the status of a felony charge. And then that's in the private database, and it's not one company. You're talking about a dozen of these private databases. And then it's in there as a distribution. Now it's wiped away. And the only record of what happened in that charge is that flawed and accurate, it was a felony distribution. We see this all the time in other instances. The expungement problem has been a huge challenge for those of us that make their life's work with poverty law. And so there have been other solutions, such as the required registration of by these companies and commitment to do contemporary searches. I'm sorry.
That's all right. That's all right. Your time's up. But I started this by asking that question. I appreciate your advice on that, and so I appreciate you coming and providing testimony. Thank you.
Thank you for doing this. It is everybody in the commission. This is leadership that this is maybe something good in 2020. This is something critical, and you cannot, at the end of the day, Virginia cannot walk away from this. It is, we talk about the symbolic differences in racial and economic injustice. This is what it actually means in real life.
Thank you so much. I appreciate that. Right. We do have two more members of the public, and Sheba Williams. Ms. Williams?
Yes, good morning. My name is Sheba Williams. I am the Executive Director of No Left Turns Incorporated. I'm speaking in support of automatic expungement. This process will remove multiple layers of barriers that impact individuals with past court and justice involvement. The burden of the current process tells directly impacted individuals like myself that we do not have a process for forgiveness, and we don't allow any relief for those who are arrested, pay a bond, pay an attorney, miss time away from work and family, and potentially lose employment, housing, custody of their children, and other forms of income. They then have to relive the trauma of being fingerprinted again, then paying a fee that's close to $100 to appear before a judge and a prosecutor. Virginia has one of the lowest recidivism rates in the country, which means that even without expungement, only around 23.4% of individuals return to prison. I echo Senator Servell and Lynn and Rob for addressing the private background companies. And I hope that regulation of these entities will also be evaluated with this process. Thank you for your time.
Thank you so much. Thanks for coming and testifying. And then we have Wayne Huggins from the Virginia State Police.
Thank you, Madam Chair. It's a pleasure to be here with you this morning. And you've already addressed one of my concerns, and that's access to the records for pre-employment purposes for employees of the Department of State Police. And secondly, I'll just mention, like Mr. Jones, the proposed bill that I've seen here before me contains a whole host of responsibilities that would fall to the state police. And I would just hope that you would ensure that we receive the necessary resources to do this and do this correctly. Thank you.
Thank you so much. And I appreciate your testimony. All right. Delegate Mullen.
Thank you, Madam Chair. I just wanted to speak to the work of the Crime Commission here for a second. First, I want to apologize. I was not here for some of the early part of this meeting. I was in circuit court myself. I think that this is an incredibly necessary bill. The work that has been put in by the Crime Commission, I think, is pretty admirable. I'd like to just make sure that I'm on the record as voting with the majority in all of the motions to amend, as well as eventually to approve this. Virginia needs to step up, and we need to be able to make some significant changes. Luckily, this is only the first part of a two-part process, and I know the Crime Commission is going to continue to be working on this between now and January. And so I think some of the things that have been addressed, we will be able to address then. Thank you.
Thank you, Delegate Mullen. All right, so through testimony, there were some suggested amendments from the public. I just want to start with the Supreme Court. Colin, if you could remind us what the suggestions were.
Thank you, Madam Chair. Yes, from the Supreme Court, we'd heard a recommendation that the clerks have immunity for acts that do not constitute gross negligence or misconduct in the event that they inadvertently release a record that was automatically expunged, which they should not have released. And second, the courts had asked for access to the information for hiring purposes in regard to clerks, magistrates, as well as judges to screen for prior convictions or working in the courts. Those were the two proposals from the courts.
All right, so Colin, with the first one, there's immunity already for clerks in the code somewhere.
Madam Chair, I believe so. It's been a long time since I would have laid eyes on that particular statute, but I believe there may be immunity for both the district and circuit court clerks for such actions.
Right. How does the committee feel about that amendment?
Madam Chairman, I have a question for Colin.
Yes.
So, Colin, I understand that this bill gives access to expunged records to some limited people, and I guess we're talking about adding one. But given the fact that there's no database of expunged charges that will ever exist anywhere, if somebody lies to you and does not disclose an expunged charge to you, how would the state police or law enforcement or anybody else go and figure out there's a record they need to go find?
And Madam Chair, if it is not disclosed, that information would still be available upon a request to state police as part of the hiring process. So my understanding for law enforcement purposes is a person has to undergo a background check with a criminal history portion of that background check, which would turn up when law enforcement ran the criminal record.
Madam Chair, could I ask Colin another question?
Yes, please.
So you're telling me that if something is expunged, it's wiped out, it disappears from CCRE, and that if the Fairfax County Police Department were to submit a request to the Virginia State Police and say we'd like to see the criminal background of Mr. Smith, that the state police would produce both the CCRE report and all expunged charges if the police department didn't know any expunged charges existed?
Madam Chair, Senator Sturvell, with the automatic expungement process as set up, the charge isn't removed from the criminal history record. It's still on the record. It's just only available for certain purposes when the record's run. So, for example, if somebody was running a background check for law enforcement hiring, that charge would show up versus a background check for some other type of hiring not covered by an exception to the criminal history record. Then it would up on that record.
One last question,
So-
Madam Chair.
Yes.
Is that the way it works today?
Madam Chair, Senator Sturvell, no, the expungement process today for the non-convictions, if the charge is expunged, it is actually removed from the criminal history record exchange, so it would not be in there. So that's one difference between the automatic expungement process and the traditional petition-based expungement process, is that the record that is automatically expunged still exists and available for certain purposes.
Okay.
Colin, it's Mike.
Yes.
Can you hear me properly?
Madam Chair?
Yes, please go ahead.
Colin, this is consistent with the process in most of the 38 states that already exist. In fact, it's a little bit more progressive than in other states. Isn't that right?
Madam Chair, Delegate Mullen, the automatic expungement system that is being proposed, is that your question?
Yes.
Okay. Madam Chair, Delegate Mullen, yes, this is, in terms of the breadth of the program, it is progressive, but in terms of the availability of the records, it is generally consistent with what you're seeing in terms of convictions, because you still do want those convictions available for certain purposes. And even in the automatic expungement process that we had discussed in Pennsylvania, those records are generally maintained and available for various uses as well. So the concept of preserving the record is not outside the norm.
So just to put a finer point on that, Madam Chair, so
yes,
this is particularly progressive in the breadth in which it is being handled, but consistent with other states in how we are limiting access to those records.
Madam Chair, Delegate Mullen, that is correct. There are very few states doing an automatic expungement on a large scale right now. Only 4 have enacted legislation. So we would be one of 5 states at this point that has enacted legislation. However, the idea of keeping the records that have been automatically expunged is consistent with other states, I believe. I can't recall the numbers off the top of my head, but something close to 40 of the states keep the records available for some type of law enforcement function, and a vast majority keep it available also for certain types of background checks.
Thank you.
So I just want to go back to where we were. We talked about the Supreme Court's suggested amendment. I guess it's time for me to go to the committee to see how they feel about that.
Madam Chair, and those were the immunity as well as access for hiring judges and staff as well as screening judges. Is that correct?
That is correct.
Thank you, Madam Chair.
All right. So I simply, those amendments, I would say, in terms are there before us. Does any member want to see that the bill amended in that fashion?
Madam Chair?
Yes.
I would move that amendment for the second recommendation. The first recommendation about clerks, I believe, is already covered. So I don't think that's necessary at this time, but I would move the Office of the Executive Secretary's recommendations for judges and the like.
Kristen?
Madam Chair, just wanted to double check. We have not thoroughly researched the immunity, so if we could have a little flexibility on that to make sure that district court clerks and circuit court clerks both are granted that same level of immunity. Just want to make sure that we cover that properly.
Okay.
Then, Madam Chair, I'm happy to move the clerk's immunity if it's necessary.
Right.
I just happen to believe off the top of my head that it's already covered.
Right, and we'll verify. All right.
Yeah, Madam Chairman, speak to that
Yes.
motion. In my conversations with the circuit court clerks is that they do not have immunity because they're constitutional officers as compared with the court. So I'm pretty sure they would need to be covered, but I haven't been able to find that in the code poking around here.
All right, thank you. All right, members,
This is Lori. I'll second.
Yes, Lori, thank you.
Thank you.
All in favor, say aye.
Aye. Aye.
All right, thank you. Was there any?
Madam Chair.
Yes, ma'am. Yes, Senator?
Thank you.
Thank you. All right, so this is before us. So I guess the question is, does the Crime Commission endorse legislation?
Madam Chair.
Aye.
So this is Delegate Adams.
Yes, Les.
And
yes.
If there's a time for discussion on this, I'd like to make a few comments.
Absolutely, yes. You have the floor, Delegate.
Well, thank you. And I want to say, Madam Chairman, I do appreciate the opportunity to be on this commission. This is my second term commensurate with my election to the House of Delegates. So before this year, I was one of the newer members. But it's incumbent on me to say I am the only Republican on the commission now, which is a dramatic departure from how things used to be. Now, that was not true in the House with the House appointments. And I thank the Speaker for my appointment and for the appointment of then Delegate Collins, who has since become a member of the bench as a judge. And so that just leaves me. It was a big disappointment, I think, when the Senate majority decided to remove all Republicans and not replace any new Republicans from the Senate. And so we know that the decisions coming out of here are not truly bipartisan as measured by this House, even if I were to endorse something, myself. And it's also my understanding, as I mentioned, I haven't been on the commission as long as some others, but that at least over the past decade, that decisions of the commission were unanimous, or at least unanimity in goals was determined prior to a recommendation from the Crime Commission. And I stand to be corrected because, as I say, my appointment began in 2018. But if we're departing from that, that is regrettable, I think, because and I can tell you just again from my own experience, having served in the General Assembly since 2014, when a recommendation came from the Crime Commission, it carries a lot of heft. And I don't recall a scenario, at least in the House, where legislation was introduced, passed out of committee, and then failed on the floor if it had the recommendation of the Crime Commission. Again, I stand to be corrected. We cover a lot of bills in session, but that is my general impression. And that is almost certainly not going to be the case with the proposals that are before us today. Not just this with the expungement legislation, draft legislation, but also on the other earned credit legislation, which is, these are major policy determinations. And so, I went back, looked at the existing code that sets out the purpose of this commission. And the purpose of the commission shall be, again, quoting directly, shall be to study, report, and make recommendations on all areas of public safety and protection. And in so doing, it shall endeavor to ascertain the causes of crime and recommend ways to reduce and prevent it. And those are the first words of the purpose of the commission. So I don't deny that the concept of expungement for instance, would fall under that general purpose. It clearly relates to crime. But we had a very short presentation today by staff that did not give an analysis. And I would say, when you go back and you look at when he started off, Colin did, with the purpose, he says, why are we considering that? And he says, well, a criminal conviction has these effects on someone's life. And Madam Chair, in your comments, it was it's important that people have a second chance. Well, those are not. What's being lost here is, what is the purpose of the commission is to study, but in terms of how it affects public safety. And I think that evidence is out there. One of the things I would have liked to have seen is, can we categorize states into different, besides what we have presented here, but into different categories that mark correlations of certain data. And you heard Colin's answer to me was that no, they don't have that. For instance, where do we rank on recidivism? Now, we know that Virginia has the best recidivist rate in the country. So we know we're not going to have anyone better than us on that score, but it would be curious to see, where the other states were that have some sort of automatic expungement. Also, in terms of the restitution, for instance, that is paid out to victims. And part of the reason I'm going to be opposing this is, we are clearly moving from a victim-centric approach that wants to make sure that victims are made whole, that public safety is protected, to a different goal here. And I'm not saying it's not a goal that has a real argument behind it. I'm not saying that at all. I'm not trying to impugn anyone's motives. I'm just saying that this is a different way to approach the work of the commission, where, we may have a shared public safety concern like human trafficking or sex trafficking. And there is an extended period of time of study and analysis by the staff of this commission that comes back and has, over the course of several meetings of a commission, a decision made of how to remedy that problem. Here, we've identified a different problem. And just to think about the timeline on this, I think, from the data that I saw earlier, there have been a lot of expungement-related bills that have been introduced over the years. But I think it was up to 27 different bills that were referred to the commission. But basically, we have, the staff in this case is saying, well, we're going to kind of look at what other states have done, and we've decided that Pennsylvania, here's a model that the executive committee likes. And I appreciate being included in those discussions. I do, and when I was able to appear. But it's interesting, Pennsylvania is the only state that has a large, I think he said Colin said, a large scale model that is in place, is working. And so, or it's actually being used. And so this is a dramatic, major piece of legislation to change a lot of things. There's a lot of practical concerns that I don't know that can be addressed in one meeting like this, especially in this context on Zoom with limited public participation. Some additional questions that have come to my mind is thinking about how is it going to affect a jury trial? How is it going to affect the disclosures that the Commonwealth must make? There's a lot of different practical concerns, but my objection is more broad, is more than that. And for those reasons, Madam Chair, I'm going to be voting against the legislation. That I hope that we will not adopt this as recommended from the Crime Commission. I think if it could be introduced to session, that's one thing. But with having the moniker of endorsed by the Crime Commission, I don't think is appropriate for this type of legislation. Again, this is something that was looked at since July, when this commission was first organized and put together. Here is our first full meeting after that organizational meeting. So I thank you for allowing me the floor to make those comments, and I hope they'll be considered by the other members of this commission.
Thank
Madam
you,
Chair.
Delegate Adams. I'm compelled to say some things because it is under my leadership that this study was done. And I want the public to know that I put these to a study and faced a lot of criticism for studying it. But I tell you why I did. I realized that we were creating inequities in our system. A bill came from the Senate where there was apparently an agreement made that left out victims of sex trafficking, that left out other crimes. The study of this measure is no different than any other study that the Crime Commission has done. And I have been on here, my guess is it's probably 9 years at least. The only difference is that this Crime Commission has the first African American to chair it. The length of this study is no different than the length of any other study. In fact, being on this Crime Commission, usually our first meetings would happen in September. You talk about public safety and protection. This falls squarely within public safety and protection. We heard testimony about the very fact that there is access for prosecutors, for police, when in hiring and deciding who they will employ. This falls squarely within the definition of our duties as a crime commission. And Delegate, I did want to make sure that you were on our executive committee because I do believe it's important to have differing views. And I'm glad that you're able to participate in some of the meetings. I want everyone to realize that yes, this is a shift. If someone has committed a crime and paid their debt to society by either doing time in prison or being on a period of probation, it is very important that after a specified period of time, and in this bill we have 8 years, that they have the ability to have a clean record. I want every one of us to imagine the stigma that comes with having something on your record. Every time you apply for a job to feed your family, your heart pounds, wondering if that will be the reason you're denied a job. You have the stigma if you get social welfare to feed your children. Yes, Pennsylvania is the only one that has this progressive policy that says after people have done their time, we're going to give them a second chance at life. There is no reason that Virginia cannot also be a leader. It is our time to be bold, to step out. If we are too scared to do so, fine. That's fine. And you have your different opinions. And I would say that anyone who doesn't support this, I don't mean to imply that you're scared, but I do want to make clear that we're still sort of stuck in the construct of this state, which allows convictions to be on people's records and they have lived a clean life. Right? Same shot that I have and that every one of us have to feed their families. And as chair of this commission, I take pride in the fact that I have pushed this through. And I want this part of our special session agenda. I hope it passes the House. I hope it passes the Senate. If Senator Servo has some concerns, and I think he raised some good points, I'm looking forward to working with him to improve this piece of legislation. This is very important to people's lives. And I understand that we have differing views, but I would say this is also a bipartisan issue. I have heard from organizations that certainly would have opposed me in the past. But this goes across race, this goes across gender, this goes across socioeconomic strata. This is a big deal. So I am, it's definitely historic. But I appreciate the comments of everybody, and I'm looking forward to a motion on this.
Madam Chair, I have a question. Madam Chair.
Yes.
Madam Chair. Madam Chair, I certainly share your sentiment, and I want to associate myself 100% with your remarks, because not only have we studied this issue, you know, like I know, many of us are bombarded by groups and organizations in our communities, NAACP, you name it, all the groups that are concerned about this issue. We hear from them almost on a daily basis. As a small business myself, I've had people to come to me year after year after year who've had crimes that they committed when they're in their very early years of life. And they're still trying to find a way to make a living for themselves and their families. And for people to be so insensitive to the needs of people to take care of themselves and their families, what do they think they're doing except trying to, or in some ways, drive them back into a life of crime? People are not going to starve. They're not going to let their children starve, and they are going to try to keep a roof over their families' heads. It is unconscionable to me to think that in today's society, people want to have other people live without any hope. And so with that, Madam Chair, I share your passion. And if a motion is in order, I move that. I think Senator Edwards wanted to make a statement before the motion.
Yes, Senator Edwards.
I just wanted to associate myself with your remarks.
Yeah, I have a question of Colin, if he's available. And the question is this: Did I understand him to say that expungements by petition, where you go to court, are different than these automatic expungements in that the court-ordered expungement after a petition, it's just off the record. It's not available anywhere. Did I understand him to say that? I'm not sure. Can you explain that to me, Colin?
Madam Chair, Senator Edwards, there is going to be a difference between a petition-based expungement and an automatic expungement for the time being until we address the petition-based expungements in the next session. But essentially, a petition-based expungement as currently exists is for non-conviction, something that did not result in a conviction. If it's granted, the offense record is removed from the criminal history system altogether. It's stored separately, but it will never show up on a person's criminal record at all when a record is run. And the court record is sealed away at the court. I believe they have to maintain them for a minimum of 3 years, but then there are some varying standards for record retention. So that is the expungement system as is. The record comes off the criminal history and it's physically sealed. With automatic expungement, the record would still be on the offense would still be on the criminal history record. So if state police ran the record for a certain purpose and it's permitted to be disclosed, then it could be disclosed, such as for hiring a law enforcement officer. A record check for somebody applying to be a law enforcement officer, the record would appear showing that they were charged or convicted of an offense, and the record would still be available in the court system so long as you had a court order to access the record.
Madam Chair.
Thank you, Madam
Yes,
Chair.
Paul.
This is the first time I think we've had the public come in and voice their views. I was very impressed with what Lynn Bennett said, and I think Senator Sherrill said the same thing. I was not aware of all these private data collectors that make all this information available. I would be more comfortable if we could incorporate that in the legislation. I think that's a very important factor. I'm not sure we can do this in a special session. I'd be more comfortable putting it off to January to make sure we get it right. And so, like the Senate has basically already finished today, they're finishing the committee recommendations, and I don't think we're going to have any more committee recommendations at this point. We can always, of course, take over whatever the House wants to send. We're going to have to deal with that as well. But I'd feel more comfortable if we would get this right and put it off to January rather than trying to get it done during the special session. That's my personal view.
Madam Chairman.
Paul. Paul, then Senator Servo, and then Chief Boone.
Madam Chair, I would like to make a motion and speak to the motion.
Yes, Paul.
I am very supportive of this legislation. to automatically expunge nonviolent crimes. Really, they're driven by poverty. And after 8 years of a clean record and having paid their time, and I have to say that this is good for public safety. I have to disagree with my esteemed colleague, Elliot Adams. This is good for public safety. It allows for former incarcerated to be productive citizens and honest members of society going forward. And by sealing these records after this 8-year period of time of being clean, we are giving them a chance to be able to get apartments, get housing, get jobs, get clearances, things that they need, get loans for higher ed. And I do agree that with Senator Edwards that we need to also go after the private entities out there, the databases. I think we should start now, get this done. We've worked hard all summer on this, and it does have an enactment clause that's going to take place in a few years. So, you know what they say about planting trees. If you it takes a long time to get them to grow. You might as well get that seed in the ground now. And I think it's time, and I agree with the chair's remarks. And so I would move that the Crime Commission endorse this bill.
Senator Serbell and then Chief Boone.
Thank you, Madam Chairman. And I also likewise, I appreciate the work and the effort that's gone into this. I think it's a good, first stab. And I also want to say that I wholeheartedly endorse the concept of expanding expungement. I've been trying to expand expungement for 11 years in Virginia since I was first elected. And I've always thought that Virginia's process is unduly restrictive, and that's evidenced by the presentation we got at the beginning. However, I also think there's a material difference between automatic expungement and petition-based expungement. And automatic expungement, to me, is like a mandatory minimum sentence in that it doesn't take into account the circumstances of a situation, and which is critical in ascertaining whether a remedy is appropriate. And I think it's the sort of the direction we've been going in the last 12 months, at least, in the legislature with regard to criminal justice issues. I think automatic expungement, has possibilities. The list is critical. The list that's in front of us right now, I have significant concerns about. For example, the involuntary manslaughter expungement, automatic expungement, and grant expungement to a guy like I had a case about 12 years ago named Edward Ludwig, who shot his wife 7 times, got convicted of involuntary manslaughter, ended up getting a 3-year sentence. This would give him an expungement. I could say a lot more about him, but I won't. There's also a series of arson charges on here. In my conversations with detectives and Commonwealth attorneys, and also some research I did last night, early arson activity by people is often a pre-indicator of sexual offenses later in life. And that's what many detectives have told me. And that's one of the reasons I think you need to keep certain convictions on people's records for a period of time, because they can be a signal of things to come, which is why and that's obviously for felony arson. I don't think there was any misdemeanor arson on here. But this list, I think, needs some refinement. It seems to me that traffic offenses are the first thing that ought to be considered for automatic expungement, as opposed to misdemeanors. But and I think there's a reason other states haven't done automatic expungement for felonies. I'm totally supportive of making expungement of felonies possible by petition. But automatic I think takes us to a place that I'm not sure any other state's gone, except for maybe California. Then I also think it's important that our decisions be based on evidence. And I'm not 100% understanding of the evidence that backs, for example, the list. Then I'm also concerned about retroactivity. As somebody who's practiced law for 24 years, I can tell you that many of the offenses on this list, such as disorderly conduct or trespassing, are often legal fictions that are used to obscure other conduct, such as, for example, I've seen indecent exposures amended to trespassing. I've seen indecent exposures amended to disorderly conduct. I've seen assaults and batteries amended to disorderly. There's other offenses that are on this list that are often associated with domestic violence, such as damaging telephone lines or intercepting messages, abuse, profane, threatening phone calls. I've seen those in my domestic violence cases. And I think if there's a history of somebody threatening someone with physical threats, whether it's by phone or email or by ripping their phone and destroying it, but maybe not hitting them, I think those are things that we need to know about in the domestic violence situation. So, I mean, these are issues I think that we need to talk through and vet and think about before we sort of grant automatic expungement to people for these things. And then lastly, I'll just say that, or two last things. One is that obviously the private sector effects you've heard a lot about. In fact, I think what we heard both in the Legal Aid Justice Center and Mr. Bennett, maybe somebody else, is that this bill as currently exists will actually do harm to people instead of solving the problem we're trying to solve. And that's, again, this private sector data company thing is something I've been trying to get solved for 6 years. The day before my hearing on my bill last session, I had 18 lobbyists that showed up at the last second to oppose my bill. Getting through the concerns of that volume of people and stakeholders, and those were all private sector, that doesn't even deal with the public sector folks that have an issue, is going to take a lot of time. And we also have two ongoing studies. We have our barrier crime study that both bodies passed, Senator Edwards' bill. We also have the data broker work group that Jay Kotz is currently assembled, that Delegate Ayala is heading up, that's also working on these issues. And, you know, I think there's merit in continuous discussion, but I really think that right now it's premature for us to be making a final decision on this and putting a stamp of approval on it. That's why, between the harm and the other issues that I think need to be worked out, I can't support it as it's drafted right now, but I support continuing the discussion.
Thank you, Senator, and I appreciate that. And I this is a process and a discussion, but I would say Virginians are waiting, and I've been criticized for putting stuff to study. So I mean, we can go ahead and study a bunch of stuff for years and years and never get to do anything. So here's an opportunity, and it's a process, and I think that we can continue to improve upon the bill. Chief Boone.
Madam Chair, good morning. I support this bill the way it's currently calibrated. I speak professionally. I don't see any impasses that will create any real concern for public safety from my perspective. Personally, having been arrested a couple times as a young man, I recognize opportunity and second and sometimes third chances. As you know, I am the chief of police here in Norfolk. And if it hadn't been for those second and third chances, I would not be here today. I possess all the education that one requires for this position. I possess all the executive leadership education as well. And in some cases, I have more than most. In the African American community, second chances are mandatory. They're necessary. I stand here today as a benefactor of those second chances or those third chances. So I just wanted to calibrate my perspective and make that known for public consumption as the police chief here in the city of Norfolk. Thank you.
Thank you so much, Chief. I believe there was a motion on the floor by Delegate Krizek.
Madam Chair.
Second.
Here you go.
This is Senator Lucas. I second, Madam Chair.
Thank you, Senator. Delegate Mullen.
Speaking to the motion.
Yes, please.
I just want to note something. I've spent my career as a criminal prosecutor with the goal of always protecting victims first. Keeping the community safe is what wakes me up in the morning and keeps me up at night. But what I can say is that this is not going to be something harmful to victims of crime. In fact, the criminal justice system is duty bound not only to punish, but to rehabilitate. And this is an acknowledgement of that process. And so I commend the commission on its work, and I will be supporting this as written.
Great. Thank you, Delegate. I've been advised in listening to the testimony I was asking about, and Colin, I'm going to turn it over to you. to talk about a possible change we can make so that we have time to deal with the third-party vendors and reporting.
Thank you, Madam Chair. In hearing the concerns of the Crime Commission, it does appear there are significant concerns about the third-party reporting. That is something we have looked at in other states, but as has been noted, it is rather complicated because of the intertwinings with the federal laws and there's preemption issues, as well as just the amount of data companies that exist out there. So I know one proposal had come up was a reenactment clause. If that would be the will of the commission, we could attempt to work on a reenactment clause. In terms of the process, I think I would have to turn it over to Director Howard to talk more about the process for the reenactment clause. But that is something we have already started to look into, and it does sound like there's more work going on in the state on that issue. So we're not starting completely from scratch on that issue.
Madam Chair, we can certainly add a clause to this legislation. As you can see, there are numerous ones already included in the bill. Perhaps we could report back to the Crime Commission next year with some of our findings and any recommendations after talking with stakeholders.
So I know that there was a motion on the floor in a second, but I do need to find out about the will of the committee with that reenactment clause, and something that members would like to see.
Madam Chair, John Edwards here. It needs work. We really haven't gone over all of especially the felonies that are automatic. That's something that needs to be looked at, as well as the private sector involvement here. And I certainly would hope that as I say, I'd feel more comfortable if we waited till January. But if you want to move forward at this point, I think at a minimum we ought to have a reenactment clause.
Madam Chair, Delegate Krizak, I'd accept that as a friendly amendment.
Right. It's been, I guess, motion second. We have to include the reenactment clause on there. All right.
I have a question. Just to clarify, is that to 2024 when you say the reenactment?
Yes, Kristen, is that correct? To 2024?
Thank you.
Yes.
Madam Chair.
Yes, Senator.
Sorry, I just have a question. So we're saying that we're recommending that this bill not become law unless the legislature votes on it twice?
That was my question. I'm about to ask that to Kristen. Make sure that we all understand what we're saying.
Okay, because I don't think if it's a reenactment clause, I would assume it would need to go till 2022 or 21 or something, not 2024.
My understanding is it's a reenactment clause that we would have to enact it twice.
Question, Madam Chair, was there a delayed reporting? I'm sorry, was there a delayed enactment?
Yes, Delegate, there was into 2024 because we had to get the systems of the courts and the state, the police together so that this could happen.
So then with that would mean that we needed to perhaps go out to 2024 for reenactment?
Well, there was some concern from some members about the third-party reporting. I was trying to address that. Personally, I think that we could pass this bill and address it in a separate bill, but.
Madam Chair.
Oh, sorry.
I just want to note that while we have some second enactment clauses, they are spread out over that time period. So we may run into some issues having a reenactment clause in 2024. If we wait to do that, we may jeopardize some of the other things that need to fall into place. That perhaps maybe we just add a second enactment clause for us to report back to Crime Commission, and then at that time make some changes rather than the reenactment clause.
All right, then, Paul, if you don't mind withdrawing your motion, I'd like the.
Okay, now, Madam Chair, I withdraw my motion.
Right. And so the new motion would be to add a second enactment clause.
Yeah. So.
All right. Is there a
Second.
Second.
motion and second that we add an additional enactment clause with a report back to the Crime Commission? All in favor?
Aye.
Aye.
Any opposed? All right. Now it's time for us to decide whether we endorse the legislation as amended. All in favor?
Aye.
Aye.
All right. Senator Lucas? She's there.
I was muted. Aye.
All right. Right. And Les, Delegate Adams, you're.
Delegate Adams is a no on that question.
All right. Senator Serville is a no. For your support, Senator.
I'm a no.
I know. I got that loud and clear.
Right.
I hope you
But
still.
we're convinced you're going to help make it bill better going forward.
Right. I hope you'll still be helpful in trying to make this better. It means so much to so many people. Your knowledge is needed. So, okay. I think we have 2 no's. Senator Edwards? Right. All right. So the legislation is endorsed. We'll keep moving through. I'll keep in contact with the senators. And I appreciate everyone. We almost on time, so we're going to move on to earned sentence credit bill by Colin will make the presentation, and we do have the bill patron with us as well, and I think he wants to make some comments after the presentation. We'll hear from public testimony, just like we were live.
Madam. Make sure I'm unmuted. All right. Madam Chair, are you able to see the PowerPoint presentation on your screen?
Yes, I am.
Thank you. Well, good afternoon, Madam Chair, members of the Crime Commission. Colin Drabert, Deputy Director for Crime Commission staff, and I will also be providing a presentation today on earned sentence credits. Today's presentation will provide an overview of the earned sentence credits in Virginia and the sentence credit structures of other states. The presentation will also address the Department of Corrections prison population in Virginia, including recidivism rates. The goal of this presentation is to inform policy decisions related to the draft legislation. Ultimately, sentence credits provide individuals the opportunity to reduce the lengths of their sentences. Earned sentence credits are meant to incentivize participation in programming while incarcerated, and good conduct credits are meant to reward good behavior while incarcerated. The current earned sentence credit system in Virginia exists as a result of the abolition of parole and the implementation of truth in sentencing in 1995. Anyone convicted of a felony offense that occurred in 1995 or afterwards is not eligible for parole. However, those individuals are eligible to earn sentence credits to reduce their sentences by up to 15%. Individuals incarcerated for an offense committed prior to 1995 are eligible for both parole and other good conduct credits. In regard to the structure of the current earned sentence credit system in the Department of Corrections, that is governed by regulations promulgated by DOC. The earned sentence credit is broken into 2 levels. The class level 1 through class level 4. Ultimately, the individuals in level 1 participate in programming and have no or limited infractions while in programming. Persons in level 2 have good participation but may have some minor infractions. Persons in level 3 participate, but generally have multiple infractions, and individuals in level 4 either do not participate, have serious infractions, or are ineligible from earning sentence credits because they're serving life sentences. Ultimately, per the Department of Corrections, 83% of the individuals that were released in 2019 were earning the maximum rate of 4.5 days per 30 days served. As you can see from this chart, the total population of state responsible inmates in Virginia has declined over the past 5 years to slightly under 35,000 individuals as of fiscal year 19. By state responsible, what I'm referring to is a person convicted of a felony and sentenced to 1 year or more of incarceration, or a person convicted of parole, a parole violation, and sentenced to 2 or more years of incarceration. Looking at that 35,000 individuals who are incarcerated as of fiscal year 19, 91% were serving an offense that was committed during or after 1995, meaning that that 91% of incarcerated individuals is not eligible for parole, but is eligible for the current earned sentence credit program. The average length of sentence of those that 91% of individuals is 15 years. However, the average length, when you remove some of the high-end outliers, is approximately 10 years. When you look at the demographics of the 35,000 individuals that were incarcerated as of fiscal year 2019, you'll note that a vast majority were male and a majority were between the age of 25 and 44. You'll also note that Blacks are disproportionately represented as they account for 41% of that prison population, however, only for approximately 20% of Virginia's overall population. Also noteworthy is that nearly 3/4 of the group has a violent offense on their criminal record. By violent offense, DOC is referring to the definition used under Title 17.1, the more expansive definition, and not the more restrictive definition of violent offense used under Title 19.2. As part of this study, staff wanted to examine how Virginia's earned sentence credit system compared to other states. As you can see from this map, the 24 states that are in the dark green offer both earned sentence credits and good conduct credits with separate time accruals for each, meaning that a person can be awarded for credits for good conduct and separate credits for earned sentence credit participation. The 7 states in the lighter green also offer both earned sentence credits and good conduct credits. However, those credits are combined into one overall time accumulation for both good conduct as well as program participation. Then you have 18 other states that either offer earned sentence credits only, good conduct credits only, or no credits at all. Pausing on this slide, the Crime Commission staff has put together several tables to look at Virginia as in relation to what goes on in these other states and their sentence credit programs. That was emailed out this morning with the cover sheet, the earned sentence credit study. And that packet has a breakdown of the various states you just saw in the map by where they fall in terms of how they offer earned sentence and good conduct credits. And part of the reason for that is in looking at these other states, staff attempted to determine the maximum amount of credits that an individual could be awarded, or what was the most common number. And what we found is that those maximum credits vary significantly between states, both in terms of how they're computed and how they are awarded. And I will just cite some examples because I think it is easier to do that way. For example, looking at the 9 states that only have earned sentence credits, Massachusetts offers 10 days per month. However, they have an additional 5 days in that for individuals working in state hospitals or schools. Then you look at Ohio on the bottom of the list, their maximum sentence credit is 8% of the term. Similarly, when you look at the 24 combined states that have earned sentence credits and parole accruing separately, Colorado offers up to 25% of the sentence in terms of a maximum for earned sentence credits. And then looking at the six states that combine good conduct credit and earned sentence credit, you have Missouri that offers 2 months each year, and New York that offers 1/3 of an indeterminate sentence or 1/7 of a determinate sentence. So because of all the ways that these states classify and or combine sentence credits, it was incredibly challenging for staff to come up with a number that is kind of most common across the other states engaging in these practices. And it became much more challenging, particularly in the 24 states where you can get a maximum amount of earned sentence credits for program participation and then add good conduct credits on top of those. And continuing on with the tables that were provided to Crime Commission members, what staff also looked at in these other states were the types of offenses or sentences that were excluded from being awarded sentence credits. And what we noted, there were 20 states that excluded individuals sentenced to life or life without parole. There were 20 states that were excluding some violent offenses, again, for purposes of staff definition, meaning injury to another person. And then there were 17 states that excluded individuals convicted of a sex offense. Also significant to note was that there were 11 states that had no exclusions in code. And for purposes of the table, as you look at the tables that were provided, each state also includes a list of offenses within that individual state that have been excluded from either the good conduct or the earned sentence credit program. The next area that staff looked at was parole in relation to sentence credits. And what you'll see in this map, looking at the yellow states, there are 29 states in yellow that have both sentence credits and parole. The 14 states that are in the dark green have sentence credits but no parole. And the 5 states in gray have parole but no sentence credits. Then there are 2 states in the dark gray, Minnesota and Wisconsin, that offer neither parole or sentence credits. Staff also sought to look at recidivism as well as the number of individuals incarcerated at DOC over a time span. And what staff found was that since 2010, there's been an average of approximately 12,500 individuals released each year from the Department of Corrections. And looking at the most recent calendar year, there were slightly over 12,500 individuals released. In terms of the individuals released, the average sentence the average sentence served by those individuals who were released in 2019 was just under 5 years. However, again, when you remove the outliers from that average sentence, the average overall sentence of those 12,500 individuals released was slightly over 2 years. Furthermore, it's important to note that over this time period of approximately the past 10 years, what you've generally seen is about 12,000 individuals per year sentenced to serve a state responsible sentence. So generally, you're seeing about 12,000 or so individuals released from Department of Corrections each year, and approximately 12,000 individuals also receiving a Department of Corrections term of incarceration, and therefore the incarceration rate has remained relatively steady. So looking at the individuals who were released from incarceration, particularly, what DOC does is track state responsible inmates for 3 years after their release from incarceration in regard to their rearrest, reconviction, and reincarceration. And what they've generally seen over the years is the numbers have remained consistent, that slightly more than half are rearrested, slightly under half are reconvicted, and approximately 1/4 are reincarcerated on a state responsible sentence. And in looking at the reincarceration rates, DOC compares Virginia's state reincarceration rate to other states, and Virginia has consistently been the lowest among those states that report this measure. The tables, which were provided with to Crime Commission members by staff, again, the earned sentence credit study tables, also lists the recidivism rates that were reported by each of those states that were participating in this reporting of recidivism rates. And you have the numbers from Virginia in that packet as well to see how Virginia compares to each of those individual states as you look at the earned sentence and good conduct credit rates. In addition to tracking recidivism rates, DOC also tracks the predictive factors that appear to have the most impact on Virginia's recidivism rates. And as you see on the slide, these are the most common factors, predictive factors that the Department of Corrections has identified. The report on the bottom cited or footnoted the recidivism reports provides greater detail on each of these predictive factors. And what staff would note is that a review of reports from the U.S. Sentencing Commission as well as the Bureau of Justice Statistics on individuals released from federal incarceration also was consistent with what DOC is seeing in the inmates released from state incarceration in Virginia. Madam Chair, based on what staff has observed, if it is the will of the Crime Commission and General Assembly to modify Virginia's current earned sentence credit structure, there would be numerous policy decisions that will need to be made, which are contained in the draft, such as who is going to be eligible for these sentence credits at an increased rate, what the maximum earnings will be, where an individual initially be classified, whether an individual can earn credits while in local jail awaiting transfer to the Department of Corrections, how often the reviews will take place, and whether there will be any retroactive components of the legislation. Madam Chair, that concludes the staff presentation on earned sentence credits. I'm happy to answer any questions the members of the Crime Commission have before touching on the legislation.
Does a member have a question before I move to the bill patron?
Madam Chairman, I had a question.
Yes, I'm sorry. Yes, Senator.
Thank you. Hey, Colin, in the materials you guys handed out, there was a one on the summary of, I think it's state responsible offenders potentially impacted by House Bill 1532. On page 5, you all referenced the 2019 SPSHS approved SR population forecast. What is SPSHS?
Madam Chair, I believe we have somebody from Department of Corrections in the help room. They might be able to help with that acronym. I'm not sure of that off the top of my head.
Right.
Madam Chair, I believe that is reference to the Secretary of Public Safety and Homeland Security. They have a group that looks at this annually.
Got it. Okay. Colin, thank you. One other question. Colin,
yes, Senator.
So, Colin, I saw your draft. I guess you all put in blanks or with X's or something, policy choices that you all want the commission to make. Does the staff have any kind of a recommendation as to how many days credit we should give for each level?
Madam Chair, Senator Serbell, staff does not have recommendation. We had attempted to identify a common theme across states to see where other states fell, but it was such a diverse range that staff was not confident in offering a recommendation. I would note that there are other good conduct credits that apply in Virginia. I believe good conduct allowance have a 30-20-10 structure. If I could look at a statute, Madam Chair, just to make sure. And Madam Chair, I would note Code Section 53.1-201. There's a good conduct allowance for individuals that are pre-95 that has a 30-20-10 structure and 0. So that is what you see here in Virginia. There's also a good conduct system. So those are out there in Virginia code, but we do not have a specific recommendation from other states or from Virginia code in particular as to what numbers should be plugged in.
Okay. All right. Thank you.
Thank you.
Madam Chair.
Yes, Delegate.
Delegate Adams and Colin, your presentation makes clear Virginia's good recidivism rate, the best recidivism rate in the country. But do I also understand from your presentation that state responsible incarcerated persons has also been declining for the past several years?
Madam Chair, Delegate Adams, yes. And looking at the populations early presentation, I believe you've seen a decrease from approximately 37,700 in fiscal year 15 down to approximately 34,700 in fiscal year 19. So decrease of about 3,000 individuals over the past 5 fiscal years.
Just to put a fine point on it, Virginia has the best recidivist rate in terms of the fewest people committing additional crimes and coming back. At the same time, the number of people, the population of inmates that the state is responsible for has been declining. That has, and I don't know that this was in your report, but I believe that's also against a backdrop where population has been increasing over the same period of time in Virginia. General population. Is that correct?
Madam Chair, Delegate Adams, I'm not 100% sure on the population. I have not looked specifically at the population increase, but in terms of the incarceration the prison population going down and the recidivism rate remaining the lowest in the country, that is accurate.
All right. Thank you.
Does anyone else have a question? All right. I'm going to move to the patron that was the source of the study, Delegate Scott, and then we'll take public testimony.
Good morning. Thank you for having me. This bill, the bill that I introduced, 1532, is a bill to add additional opportunities for folks who do everything right. I heard what we're saying about the recidivism rate being low, and I think this is an opportunity to reinforce those positive vibes regarding recidivism and making sure that people have the opportunity to earn their way home, which is why we call this a earned sentence credit. I was grateful for Delegate Jeff Campbell on the other side of the aisle, who also introduced a bill to increase earned sentence credits, and he was gracious enough to roll his bill into my bill, because I think it is a bipartisan issue, justice reform and reducing the impact of the criminal punishment system on African Americans and others who are poor and unable to, in the vulnerable communities. This is an opportunity for them. As I listened to some of the presentation before I get into the bill, I will say that I was surprised to see that one of the predictive factors was not race, when it was clear that on the DOC site originally, I saw that it had 55% of the residents, men and women, were African Americans. But then I see a presentation today that said it's 41%, even though we still are only 19% of the population in Virginia. So I still think that's unconscionable, and not to be honest and say that one of the predictive factors is race is I think is lacking. I also will look at the budget. At the end of the day, we have to look at one of the things that they said was it's 12,000 in and 12,000 out every year. It sounds like a pretty good business model. And I think we need to take a look at this incarceration system. We're talking about billions of dollars that we spend across the board. If you look at DCGS's budget in juvenile justice facilities and correctional facilities and post-probation and parole, this is a huge undertaking. And when I had a fiscal impact, they said it would cost, I want to say $13 million to do this, but there's no calculation of any savings. So basically they said it's going to cost $13 million to reduce the prison population by more. But at any rate, I'm going to get into the bill. The bill basically has 4 levels. Right now we have a four level earned sentence credit bill. And I don't know if is it Colin? I don't know if he said what the percentage of people who actually get those 4.5 days per year, month are. But if I recall directly, and DLC can correct me, it's less than 50% of the people who actually get even the 4.5 days per year. So we're not talking about something that is a guarantee. We're talking about something that folks have to earn. It's 4 levels. At level 4, it wouldn't change. They would still get 0 days. I introduced at level 3, they would get an additional 3.5 days. At level 2, they would get 7.5 days. And for level 1, they would initially start at 13 days for every 30 days. All of this is for every 30 days. If their behaviors continued and they did well, the second year, they'd get 16 days. On the third year, 20 days. On the fourth year, 25 days. And at the 5th year, they would get 30 days for every 30 days served. So it is a process whereby you earn by good behavior will make the prison, the system there more therapeutic and holistic, and making sure that we get folks back, because as they did say, everybody's coming home. So we basically have to look at the product that we have. Is we're spending billions of dollars on this product. What is our expectations when they return? We want to keep people safer. We do want to respect the victims of violent crime and others, and we do want to make sure that we make the community safer. So that is why we introduced this earned sentence credit bill. The DOC already has a very well-documented good time award system. They have an operating procedure to implement this. They have institutional classification staff on board who could go through and implement this. I was talking to a friend of mine who works at Amazon, and when I told him that the DOC put a $2 million price tag on having to recalculate sentences, and he said, "Oh my, that's crazy." He said, "I could probably get a couple of my college kids a couple of college kids from Stanford, to run this model, get access to this system, and he could probably redo this with he said, because he asked me how many people were in the system, and I told him about 30,000. But at any rate, I think this is a time for Virginia to step up. I find it unconscionable that we say we have everybody admits every data point we say we have over policing of Black communities. We get unfair treatment in the court system. And then on the back end, we're disproportionately in this criminal justice system. And then to say, well, we're going to move forward in the future, we're going to do something. What I'm saying is we need to retroactively correct it if we can. And we need to make sure that we put the programs in place to make sure that we provide supports. To that end, I've talked to some, I don't think this is just a public sector solution. I've talked to Dominion Power. I've talked to Coca-Cola. They both want to do programming in workforce and housing and support right now to contribute to get in there. So this is the opportunity while the iron is hot to get a lot of stakeholders involved in how we make communities safer, how we make marginalized communities more impactful economically. I was listening to y'all's debate around expungement, and at the end of the day, all of this also, as Senator Lucas said, this impacts people's ability to earn a living and come back and be productive society members of society. So I think right now this bill rewards those who participate in evidence-based counseling, substance abuse counseling, learn vocational skills, and improve their educational pursuits. So the folks that do that and they do it every year, then hopefully we'll be able to give them more earned sentence credits. And I will say, Colin was talking about there are very, 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 very conservative states that already do this, that they have way more time than Virginia does. And I know we're bragging about our recidivism rate. And I think that's great. It may have something to do with liquid sentences, but it also may have something to do that we already have a good program. Now let's scale it up for more people to benefit from it and coming home. So if we're bragging about that, hopefully it's not all related to people staying in jail longer. And hopefully, and I'll entertain any questions and I'll listen to the public as well. Thank you for having me, Madam Chair.
Thank you so much. All right, what we're going to do is we're going to turn to the public. There are a significant number of people who signed up. Unfortunately, we are limited on time, so I'm going to call people, and then the committee needs to make some decisions on the bill. So first, Jen Carter from the Humanization Project.
Thank you, Madam Chair. My name is Jen Carter, and I'm co-founder of the Humanization Project. We support expansion of earned sentence credits for all people behind bars. Right now, people behind bars in Virginia have no tangible incentive or hope to be better. Despite that, there are people behind bars currently who have become amazing people. These are the people who should benefit from this bill. These are the people we want returning to our communities. By eliminating certain crimes or not making this bill retroactive, you really will have no effect on the system. What is the goal of this legislation? To counter mass incarceration and reduce prison populations that have been shown to be so detrimental during this pandemic, to begin to work against the history of racism inherent in the system that has been perpetuated by tough on crime, 3 strikes laws, truth in sentencing, and mandatory minimums, to give people second chances. This is a time to be bold, to pass real reform. Taking away the retroactivity or eliminating certain crimes from this legislation creates a piece of legislation that effectively does nothing. Lastly, I want to say, while you are here from victims today, people I would really love to hug and help, they do not speak for all victims. We know from national surveys that 61% of victims prefer a shorter sentence and a focus on rehabilitation, exactly what earned sentence credits would do. I urge you, support earned sentence credit expansion for all people behind bars, especially those who have been working to better themselves despite our current system of discouragement. I would, of course, be happy to speak with any of you all more or answer any questions. And thank you again, Madam Chair, for allowing me to speak.
Thank you so much. Next is Michelle Hawkins. Ms. Hawkins, you have 1 minute.
Hi, thank you for allowing us to speak. I'm in favour of the good time credits, and it does need to be for all offenders behind bars. So many people, the violent offenders in particular, they start off at the high-level prisons. They need to be infraction-free for at least 2 years before they can go to a lower-level prison. During this the time of the pandemic, they're unable to attend classes. Many of them are not able to work, and they are literally just sitting around all day doing nothing because they're not allowed any movement within the prison, and they're still maintaining really good behaviour, and that needs to be rewarded. And I think if you do exclude people on the purpose that they're a violent offender, or, you know, many of these violent offenders committed a crime on the spur of the moment. They didn't go out looking for it. They may have a drug deal that's gone wrong, or they've, like my friend, he was approached by somebody with a knife and he defended himself, and he's now in prison on a violent felony. Not all violent offenders are violent people, and that needs to be addressed and it needs to be looked at. And yeah, I do feel for the victims, but we need to look at what's going on within the prisons as well. And if these people have continuously maintained good behaviour, then surely that needs to be rewarded, because they're only going to continue that good behaviour when they're released. With the good time credits as well, it also looks that they will serve more time than they would be eligible for parole. So they're only getting a few years off. They're not actually getting as much as they would be eligible for parole. So that also needs to be addressed as well. So please vote in favour of this bill for everybody.
Thank you so much. Next is Jeremiah Fitz from the Virginia Department of Corrections. Mr. Fitz? Right. Paula Langbin. All right, Alice Brown.
Hi, I'm Alice Brown.
Hi.
Victim. Thank you for having me this afternoon. I just don't agree with this earned credit because the person that victimized my family, we do not get an earned credit. We're victimized every day. Our life has been devastated forever. And this person gets to get a reward for murdering my grandson. And he willfully went out and looked for trouble. My grandson did not. And he doesn't get to come home. He doesn't get a second chance. He doesn't get any earned income, earned rewards at all. His sister doesn't, his brothers, his mother, our community. If we put this person back out early, it would not be beneficial to anyone. So I just disagree totally, and I'm not for it at all. My life has been changed, never will be the same as a result of October 23rd, 2017. And this young man who murdered my grandson is still making threats and things towards my family from the inside and his friends. So why does he get a second chance? I'm not getting one. I'm constantly in fear every day. And this young man is incarcerated. So no, I don't agree. Please do not pass this. Thank you.
Camille Cooper.
Thank you, Madam Chair. My name is Camille Cooper. I am Vice President of Public Policy for RAIN, and I'm going to keep my comments very brief today and keep them consistent with the comments that I made before the Senate Judiciary Committee. In an email to the Crime Commission members this morning, I included 3 studies that talk about serial offending related to sex offenses. The first study was a study that was done on 7,287 rape kits that were submitted in Detroit. When you looked at the rape kits and the criminal history of those offenders that were identified in that study to have committed sex offenses, 39.7 were serial offenders, which means they had more than one victim, sometimes between 2 and 15 on average. The second study is the Butner Redux study. 156 offenders that were incarcerated at the Butner Federal Prison for child pornography possession offenses had between 1,777 actual hands-on contact offense victims between them. The third study is the Burke et al. Tactical Polygraph study. That study was 127 offenders that were arrested on child pornography offenses. Again, of the 73 offenders in that study that admitted to contact offenses, they had between 282 victims between them, between 73 offenders. We know through the Department of Justice that of every 1,000 sex offenders, only about 4.6 are actually sentenced to any kind of incarceration. We know that recidivism does not measure reoffense, it measures rearrest. We know that sex offenders are typically very savvy and they use rapport building and good behavior and trust building as a weapon in their crimes. This is how they groom victims, how they groom family members, parents of victims, and how they're able to perpetrate their crimes. So by providing earned sentence credits to this population of offender, you're actually taking a quality or behavior that they use to offend and which comes naturally to them, which they hone over time and become better at. And you're using that good behavior as a way to justify releasing them early. So we would ask that you please, with regards to any earned sentence credit bill or geriatric early release bill, that you exclude offenders with sex offense histories from those early release provisions. Thank you.
Thank you so much. Wayne Huggins.
Thank you, Madam Chair. On behalf of the Virginia State Police Association, we would oppose extending these types of credits to any person convicted of capital murder of a police officer. You'll recall that in 2019, the General Assembly overwhelmingly passed a bill making it clear that those convicted of capital murder of a police officer would only be eligible for imprisonment without parole or the death sentence. And to turn around, and we've recently seen capital murder
Froze.
receive light sentences. And thank you.
Mr. Huggins, you froze for like the last 30 seconds.
I'm sorry. I won't say everything other than we very strongly oppose extending earned credits or good time credits to those who have been convicted of capital murder of a police officer. You will remember that last year, the General Assembly overwhelmingly passed legislation making it clear that those convicted of capital murder of a police officer would either receive life without parole or the death sentence. And we think that's an appropriate punishment. And we have recently seen those convicted of these types of crimes receiving light sentences and being paroled. And we're just adamantly opposed to those types of people receiving anything other than those two possibilities. Thank you.
Thank you so much. And I'm going to go back to Jeremiah Fitz.
Madam Chair, I believe he might have been in the queue for technical assistance.
Oh, okay. I was given the name, so thank you.
Good afternoon, Madam Chair.
Oh, yes. Hello.
This is Jeremiah Fitz. I'm here. Can you hear me?
Yes, welcome. You have a minute?
Thank you, Madam Chair. And I will just, this is Jeremiah Fitz from the Virginia Department of Corrections. And I will just say that the Department of Corrections takes no position on this bill, as we also communicated during the regular session. We just wanted to be here to answer any questions. I will share with the committee that we have talked about in the past the fiscal impacts of creating a bill such as this. And we want to be sure that as a department, if this bill is moved into law, we want to be able to make sure that we can be able to answer what this bill is doing. In terms of our computer system, our core system is what we call our information system that is responsible for what we utilize in terms of calculations. There's a considerable amount of money that, there's $1 million expense. And we also would say that in terms of being able to make those calculations and be able to test our system and make the upgrades, we've also asked, and we also expressed this to the bill patron as well, that it would take us approximately about 2 years for all of our systems to be up to date and to be tested to make sure that we can be ready for the influx of those who be eligible under this new legislation. So with that being said, Madam Chairperson, that's all that I had, unless there are any other questions for the Department of Corrections. And we do have some other subject matter specialists who are in the queue, can also answer some questions as well. Thank you.
Beautiful. Thank you. I'll stand by. I'm sure we're going to need you. Rachel Wilson from Hopewell.